Further orders.
Now the respondent is the instigating tax grant without amendment in municipal taxing act. The petitioner brings the institution of in the education institution. Is not the instigated the penalty act is reviewed. That's why the only 24% exemption is there without the amendment in municipal taxing act. So you see the full tax.
152 al ಬರಲ್ವಾ ಇದು?
152 ಬರೋದಿಲ್ಲ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿಲ್ಲ.
Deviation ಅಂದ್ರೆ we won't interfere. Deviation ಅಂದ್ರೆ we won't interfere.
Deviation this is a different issue altogether. Reason was under the earlier act we had put up a ground floor portion. First and second floor he has been load bearing on has to come. He says there is a deviation.
Let us see what is it.
Page number 6, serial number 46.
For 46 to last, can I expect not
2014 matter,
Yes, so I
Mr.
am ready to want to That's why
46.3 and service ಆಗಿಲ್ಲ 46.3 46.3 ಸರ್ವಿಸ್ ಆಗಿದೆಯಾ ಆಗಿಲ್ಲಪ್ಪ ಸರ್ವಿಸ್ ನೋಟಿಸ್ ಹೋಗಿಲ್ಲ PS ಮಲ್ಲಿಪ ಪ್ಲೀಸ್ ವೇಟ್
Serial number 44, my lord. Serial number 44, my lord. Senior is,
ಎಷ್ಟು ಸತಿ ಹೇಳೋದು ನಿಮಗೆ ಪ್ಲೀಸ್ ವೇಟ್ ಇವಾಗಲೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಾ ಪ್ಲೀಸ್ ವೇಟ್ ಅಂತ ಹೇಳಿದ್ರೆ ನಿಮಗೆ
Page number 7, serial number 47 to 50.
50 2014 matter next week
My lord, serial number 48.1, my lord.
relist on 10th August. It is made clear that no further adjournment will be granted if arguments are not advanced. Petition will be dismissed for non-prosecution.
My lord, serial number 48.1, my lord.
Yes.
My lord, I have informed opposite counsel Gangadrappa sir, my lord. I seek for a short accommodation. in this-
Other connected matters, Mr. ಇಬ್ಬರೇ ಮಾತಾಡ್ರೆ ಆಗಲ್ಲ ಬಾಕಿನೂ ಇದ್ದಾರೆ ಸೊ ಪ್ಲೀಸ್ ವೇಟ್
serial number 44, my lord.
ಎಸ್
Senior is not in town. He's traveling due to personal inconvenience. I've informed the other side and next week may be fixed, my lord. 44.
ಫೈನಲ್ ಇಯರಿಂಗ್ ಬರಬೇಕು
We've addressed arguments previously with inconvenience, my lord. There's some inconvenience today.
44. Have you informed the respondent?
Yes, my lord. I've informed the respondent.
At the request of counsel for the petitioner, relist on 17th, it is made clear that no further adjournment will be granted.
Much of it.
45 minutes.
Hmm.
I pay the petitioner. It's I have to procure authors of the flat owners. That's out. 2 weeks that will be. I will procure
Non-filing of list of members, non-payment of court fees.
court fee minutes is further ordered. I will court fees I will pay during the course of the day.
We'll give you 1 week's time. If you don't comply with it, it will get dismissed. 45. At the request of counsel for the petitioner, a week's time is granted. Relist on 17th, if compliance is not made, the petition will be liable to be dismissed. Have you informed the respondents? 20%. Who is appearing now? Sumant has entered appearance. Simi mattant ಬಂದ್ಬಿಟ್ಟಿದೆ. Sumangla Gachanmat has entered appearance for respond 1 and 2. Delete the name of Shri IG Gachanmat as that appearing for respond number 1 and 2. Registry is also directed to correct her name. 21st.
Page number 8, serial number 51 to 56.
Have you informed the petitioner?
No.
Inform ಮಾಡಿದ್ರೆ ಮೂವ್ ಮಾಡಬೇಡಿ ಮೆನ್ಷನ್ ಒಂದು ನಿಮಿಷನೂ ಇಲ್ಲ ನೀವು ಮೆನ್ಷನ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು ಒಂದ್ ಕಾಯ್ಬೇಕು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರೆ ಮೆನ್ಷನ್ ಮಾಡಿ ಇಲ್ಲ ಅಂದ್ರೆ ಮಾಡ್ಬೇಕು ಮಾಡಿದ್ಮೇಲೆ ಬನ್ನಿ
Page number 9.
Serial number 53, Lord. I am for a petitioner, Lord. Seeking for a week's time, I inform that.
At the request of counsel for the petitioner, relist on 21st. Entry mode earlier granted is extended to next date. If arguments are not advanced on next date of hearing, petition will be liable to be dismissed. 2015, 18, 19 ಆದ್ಮೇಲೆ ಏನು ಹೇಳಲ್ಲ 2015, 16 ವರೆಗೂ please get ready.
Page number 9, serial number 57 to 63.
My lord, serial number 59, my lord.
Yes.
I appear for the petitioner.
Hmm?
I request it to be had on 9th, my lord, if your lordship's convenience.
Have you informed the respondents?
I have informed Sri Gangadrappa,
59, the request of counsel for the petitioner relist on 9.
9th, my lord. I will.
Have you informed the other councils? Sorry. Next.
Page number 10, serial number 54 to 71.
Hmm? Jenna Jagdishwara has entered appearance for response 2 and 3, delete name of 3. Pawan Kumar has that appearance for R2 and 3. Objections. He seeks for and is granted 2 weeks time finally to file a statement of objection. Objections, if any, to be filed on or before 24th August, relist on 29th August.
Number 65, hearing for petitioner, inform to the other stakeholders.
65 at the request of counsel for the petitioner, relist on 30th. Interim order earlier granted is extended.
Page number 11, serial number 72 to 74.
70,000, 1 day payment. Other side inform 74.1.
74 ಅಲ್ಲಿ please wait. ಏನಮ್ಮ ಜೋರಾಗಿ ಹೇಳ್ಬೇಕು ಯಾವ serial number ಏನು infructuous infructuous 47 correct a number 24487 you are Mr. Nityananda Naik's colleague 47 the counsel for the petitioner submit that the above petition has been rendered infructuous accepting the said submission petition is dismissed as infructuous pending IAS do not allow for consideration as such are dismissed.
Order serial number 1. Proposition.
46 ನಿಮ್ದು ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಪ್ಲೀಸ್ ವೇಟ್ ರೀಚ್ ಆದ್ಮೇಲೆ Two 2017 in the you haven't complied. You are granted only 1 week's time to comply. You did not comply. So interim order is gone. There is no interim order. Interim order has not been extended, madam. It's not been extended on 9/1. It's not been extended on 19/1. Interim order illa. Counsel for the petitioner seeks for and is granted a week's time finally to comply with office objection. If the office objection is not complied by 18th, the petition would be liable to dismiss for non-prosecution, relist on 23rd. 2017 in the itkondidira compliance.
Serial number 2, K.R. Lingaraju.
Seven. What is 14/7 direct? Have you verified?
Two directions, one to find out the petition. Second direction, order considering this as a recommendation. gone out from the record that you have made an offense.
He has made payment of 19,000 yesterday.
In this time.
So Sharad Gowda, Level Council for respond number 1. Submits on instructions that the amount of rupees 19,000 had been paid by the petitioner. On ಯಾವತ್ತು date 12/9 ಆಯ್ತಾ ಅದು
5,000 was made on 24/12/2001. And 14,000 was made on 19/1/2002.
19,000 is received by what is that date? Second payment
14,000 was made on 19/1/2000.
by 19/1/2002. And as observed by this court on 14/7/2023, the first respondent is required to reconsider the notice issued on 14/7 14/7/22. 23. 14/7 is the order. Cancellation order in
Cancellation order, sir, annexure A, which is dated 7/12/2002.
7, reconsider the cancellation order dated 7/12/2002. By that time, substantial amounts have been paid. The Sharad Gowda seeks fund is granted 2 weeks time to make a submission there to relist on 23rd.
Serial number 3. Archana KM.
Fund number 4.
Fourth of matter.
To the petitioner.
Agencies have participated. The agencies were not qualified. Therefore, we have rejected both the tender application. But now we have made a request to Unix. So that assist in the matter. They are very estimation as well as the flow chart.
UNX ಇದೆ, NIC ಇದೆ.
Therefore, we have Unix is a government of Karnataka. We have made a request. Document number 4, page 14 class. And this is the other.
For the petitioner, my lords.
Yes. So when will you,
When we are pursuing very much for the project as well as the project.
new department is set up, RCCMS. They've done a very good job. rccms.karnataka.gov.in. ಎಲ್ಲ AC, DC, ತಹಸೀಲ್ದಾರ್, RRT, ಸರ್ವೆ ಎಲ್ಲ ಒಂದ್ ಜಾಗದಲ್ಲಿ ಸಿಗುತ್ತೆ. ಹಂಗೆ ನೀವು ಮಾಡಿದ್ರೆ everybody will have a benefit. The TP Vivekanand and Council respond number 4, seeks fund is granted 4 weeks time to file a compliance affidavit since the submission is that tenders had been called and the tenderers were found unsuitable. As such, further steps are being taken. Relist on 19th September, 25th September.
Much obliged.
Lords, I appear for the petitioners in this case. Lords, with regard to respondent number 3, my lords,
Who is respondent number 3, Mr. Samuel?
my lords, he's a senior counsel and I just spoke to him and he said that this has to be rectified. Annexure G. Lords, this property is valuable property on Cunningham Road. What has happened is that a small unit he had purchased, but they have transferred the whole property number in respect of the small unit.
Who is
Annexure G.
respond number 3?
Yes. He's a senior counsel. I don't want to mention his name. And so I had requested him, he spoke. The writ itself can be disposed of, my lords, because we have discussed. He said he will render all necessary cooperation in order to get this rectification done.
So you don't want to press this matter?
No, my lords. The authorities are asking for a direction from this court.
Then let them file it. They file a joint memo.
Very good, my lords. I can do it, my lords. Because he has said that he has no objection in getting this thing corrected. That is a mistake on the BBMP.
I appeal for the response 1 and 2 in this matter.
The so submit that she would be entering appearance for response number 3. Both the counsels seek for and are granted. How long do you want?
No, I appeal for response 1 and 2, madam.
1 and 2, yes. But
Please.
there's another counsel who is entering appearance.
Please, madam.
How long do you want, Mr. Samuel?
My lords, we will just file a joint memo, my lords, next week itself, my lords, because this has to be.
You let us know.
That's an
when
error
you are
with
going
the
to file.
order passed by the.
Sorry, my lords. Sorry, my
When are you
lords.
going to file? 1 week.
Or even today, my lords, 2:30 we can file it and finish it if she's ready, my lords.
Pass over. Pass over.
Very well.
She needs to get. We need
Very well.
consensus that
Very
we
well. Very
list
well.
on 10th.
Grateful. We are grateful.
The counsel for the petitioner seeks to only give 2 weeks time to comply with notice of objection. Relist on 21st.
Lord, represent the petitioner, please. No.
How to dispatch. August dispatch.
Notice ordered on 27/7, here paid on 28/7. Disbursement for charges.
The date you have. That month is to be.
Date given.
One more.
Lord, in this matter, Lord, R3 has not been served.
Is the ordered on 27th, you paid on 28th, the dispatch is on 1st. It can be served.
Please.
6. Notice is. Copy incomplete again. Annexure Silvanta Mr. Malappa.
I furnished, Lord. I furnished detail. Everything is given. I'm sorry. If any mistake is there, Lord, I'll see that.
Yuvraj doesn't normally submit like that.
No. And I'm not saying.
In one set code.
Please, Lord.
Counsel for the petition is directed to furnish one more set of petition along with all annexures on counsel for respond number 2. Notice to respond number 3 has been dispatched on 1/8, awaiting service, relist on 28/8, registry direct put up postal track record.
Please, Lord.
Serial number 7. Yes, that's it.
Around 28/7/2023. By taking orders on the report, asked me to produce the but since the annexure we itself was not saying that the license will be withdrawn, I had not produced that license. Then at 1:30 minutes, I made a submission that I have the license and plan with me, and we permitted to produce it along with me. Then court said, I post it on 4th. You can produce it before the court on 4th and article this. However, my lords, it appears that by the time I could make a mention at 1:30, the issue notice in Tiger and the whole.
R5 ಒಬ್ರು ಉಳಿದಿದ್ದಾರೆ. Who is R5?
R5 is private.
Rama Sangakulai.
Fact is, my lords, license issued to me.
Where is Mr. Bandari? Tarish Bandari? You are here, sir.
The reason why I made the mention at 1:30 was not for the immediate. Since I had not produced the sanction plan and license, my lords, the court said you produce it.
The order that you are seeking for is notice dated 17/6.
Yes.
What is this matter?
Now, my lords, license was issued to me, my lords, to put up construction. The Deputy Commissioner Milords had passed an order on earlier occasion. It is available at Milords page number 61 annexure G. Kindly see Milords page 61 annexure G. Wherein Milords he had ordered to reserve a particular property for the purposes of formation of road. Operative portion is at page 66. This order came to be passed on 8/3/2022. Thereafter, Milords, we approached this honorable court, we in the sense, Milords, villagers approached this honorable court by filing the writ petition to implement that order, which is available at page number 79. But though the earlier order came to be passed after hearing all the parties concerned, and Milords, pursuant to the orders passed by this honorable court as well as Milords state, very strangely, the Deputy Commissioner proceeds to pass an order dated 8/2/2023, saying that Milords, the property which was reserved for 25 cents of land shall be bifurcated into two parts. One 13 cents and one 12 cents of land.
13 ಗುಂಟಾಸ್ ಅಂತಿದೆ.
13 ಗುಂಟಾಸ್ ಅಂತ ಅಲ್ಲಿ ಮಂಗಳೂರಲ್ಲಿ ಸೆನ್ಸ್.
ಅಲ್ಲ, ನೀವು ಒಂದ್ ಜಾಗದಲ್ಲಿ 13 ಗುಂಟಾಸೇ ಬರ್ದಿಲ್ಲ.
ಸೆನ್ಸ್.
Respect of 13 guntas of 38 guntas in Burger. 13 cents or 13 guntas? 13 cents. Yes.
Bifurcate ಮಾಡಿಬಿಟ್ಟು 25 cents ಅನ್ನ 13 cents ಮತ್ತೆ 12 cents ಅಂತ bifurcate ಮಾಡಿ. You form a road ಅಂತ, that is the order passed by the deputy.
Yes.
That order came to be passed without issuing any notice to all the parties concerned. And on the strength of that order, now the municipality has issued, corporation has issued notices at annexure A and B, calling upon me to stop the construction.
Entire 38 cents was given to you.
Entire 38 cents was given for the public purpose.
To 4, respond number 5.
Yes.
How are you concerned with it?
We are the villagers. What they have done with us.
So is it a public interest?
No. This is my house construction has been started. India.
If it was given to respond number 5, who are you to come in between?
No. What happened? A property was given to respondent number 5. Then, my lords, for public purposes, 38 cents was reserved. 25 cents was reserved. By virtue of the order which I just now pointed out, which was available at page 61. Page 61 make I. Annexure C.
Yes.
That too, my lords, after series of litigation for almost 8 years, this order came to pass. Annexure G, page 61, the relevant portion is at 66. 13 ಸೆನ್ಸ್ ಜಮೀನನ್ನು ಬೇರ್ಪಡಿಸಿ ಸಾರ್ವಜನಿಕ ರಸ್ತೆ ಉದ್ದೇಶಕ್ಕಾಗಿ ಕಾಯ್ದಿರಿಸಲು ಕುಳಾಯಿ ಗ್ರಾಮ ಸಂಘಕ್ಕೆ ಮಂಜೂರಾತಿ ಆದೇಶವನ್ನು ಭಾಗಶಃ ರದ್ದುಪಡಿಸಿ ಪರಿಷ್ಕರಿಸಿ ಆದೇಶಿಸಿ ಕುಳಾಯಿ ಗ್ರಾಮ ಸಂಘಕ್ಕೆ 25 ಎಕರೆ ಸ್ಥಿರೀಕರಿಸಿ ಬೇರ್ಪಡಿಸಿದ ಜಾಗವನ್ನು ಸಾರ್ವಜನಿಕ ರಸ್ತೆಗೆ ಮತ್ತು ಡ್ರೈನೇಜ್ಗಾಗಿ ಮಂಗಳೂರು ಮಹಾನಗರ ಪಾಲಿಕೆ ಕಾಯ್ದಿರಿಸಿ ಹಸ್ತಾಂತರಿಸಲು ತಹಶೀಲ್ದಾರ್ ಮಂಗಳೂರು ತಾಲೂಕು ಮಂಗಳೂರು ಇವರಿಗೆ ಆದೇಶಿಸಿದೆ. This order has attained finality. They are not challenging. Now what they do, my lords? May I request my lords to turn to page 90 annexure P.
Yes.
Can you see the date, my lords? 8/2/2023, after almost 1 year. That's a 1 year. This order came to be passed, saying that, my lords, this property shall be bifurcated. Relevant portion is at page 91. ಅಧ್ಯಕ್ಷರು ಗ್ರಾಮ ಸಂಘ ಕುಳಾಯಿ ಇವರ ಕೋರಿಕೆಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಈ ಕಚೇರಿ ನ್ಯಾಯಾಲಯದ ಆದೇಶ ಸಂಖ್ಯೆ ದಿನಾಂಕ 8/3/2022 ಮಂಗಳೂರು ತಾಲೂಕು ಕುಳಾಯಿ ಗ್ರಾಮದ ಹೊನ್ನಕಟ್ಟೆ ಎಂಬಲ್ಲಿ ಕುಳಾಯಿ ಗ್ರಾಮ ಸಂಘಕ್ಕೆ ಮಂಜೂರಾದ ಸರ್ವೆ ನಂಬರ್ 12ರಲ್ಲಿ ಪೈಕಿ 13 ಎಕರೆ ಜಮೀನನ್ನು ಬೇರ್ಪಡಿಸಿ ಸಾರ್ವಜನಿಕ ರಸ್ತೆ ಉದ್ದೇಶಕ್ಕಾಗಿ ಕಾಯ್ದಿರಿಸಲು ಕುಳಾಯಿ ಗ್ರಾಮ ಸಂಘಕ್ಕೆ ಮಂಜೂರಾತಿ ಆದೇಶವನ್ನು ಭಾಗಶಃ ರದ್ದುಪಡಿಸಿ ಪರಿಷ್ಕರಿಸಿ ಆದೇಶ ಹೊರಡಿಸಲಾಗಿತ್ತು. ಹಾಗೂ ಕುಳಾಯಿ ಗ್ರಾಮ ಸಂಘಕ್ಕೆ 0.25 ಎಕರೆಯನ್ನು ಸ್ಥಿರೀಕರಿಸಿ ಬೇರ್ಪಡಿಸಿದ ಜಾಗವನ್ನು ಸಾರ್ವಜನಿಕ ರಸ್ತೆಗೆ ಮತ್ತು ಡ್ರೈನೇಜ್ಗಾಗಿ ಮಂಗಳೂರು ಮಹಾನಗರ ಪಾಲಿಕೆಗೆ ಕಾಯ್ದಿರಿಸಿ ಹಸ್ತಾಂತರಿಸಲು ತಹಶೀಲ್ದಾರ್ ಮಂಗಳೂರು ತಾಲೂಕು ಇವರಿಗೆ ಆದೇಶಿಸಲಾಗಿತ್ತು. ಸಾರ್ವಜನಿಕ ರಸ್ತೆ ಹಾಗೂ ಡ್ರೈನೇಜ್ಗಾಗಿ ಕಾಯ್ದಿರಿಸಲಾದ 13 ಎಕರೆ ಜಮೀನನ್ನು ಪೂರ್ವದ ಮತ್ತು ಪಶ್ಚಿಮದ ಬದಿಯ ರಸ್ತೆಗಳನ್ನು 12 ಅಡಿ ಅಗಲ ಮಾಡುವ ಸಲುವಾಗಿ ಸಾರ್ವಜನಿಕ ರಸ್ತೆ ಉದ್ದೇಶಕ್ಕಾಗಿ ಮಂಗಳೂರು ಮಹಾನಗರ ಪಾಲಿಕೆಗೆ ಕಾಯ್ದಿರಿಸಿ ಆದೇಶಿಸಿದೆ. He divides that 25 cents of land, 13 cents of land into 2 portions.
It has to be divided. 13 alla. 13 and 25. 38 na 2 portion.
That he can do, my.
That is what he has done.
No. 13 ಎಕರೆ ಜಮೀನನ್ನು ಡ್ರೈನೇಜ್ಗಾಗಿ 0.13 ಎಕರೆ ಜಮೀನನ್ನು ಪೂರ್ವದ ಮತ್ತು ಪಶ್ಚಿಮದ ಬದಿಯ ರಸ್ತೆಗಳನ್ನು 12 ಅಡಿ ಅಗಲ ಮಾಡುವ ಸಾರ್ವಜನಿಕ ಉದ್ದೇಶಕ್ಕಾಗಿ ಮಂಗಳೂರು ಮಹಾನಗರ ಪಾಲಿಕೆಗೆ ಕಾಯ್ದಿರಿಸಿ ಆದೇಶಿಸಿದೆ. Now kindly see what the corporation does. Kindly come to annexure A.
Yes.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 1 ದೂರು ಅರ್ಜಿಯಲ್ಲಿ ಕುಲಾಯಿ ಗ್ರಾಮ ಸಂಘದ ಜಾಗದಲ್ಲಿ ಸಾರ್ವಜನಿಕ ರಸ್ತೆಯನ್ನು ತೋರಿಸಿ ಮನೆ ನಿರ್ಮಾಣ ಮಾಡುತ್ತಿರುವ ಕುರಿತು ದೂರು ನೀಡಲಾದ ಕುರಿತು ಈ ಕುರಿತು ಪರಿಶೀಲಿಸಲಾಗಿದೆ. ಶ್ರೀ ಸ್ವಯಂಸು ಗ್ರಾಮ ಸಂಘದ ಹಿಂಭಾಗ ಕುಳಾಯಿಯವರಿಗೆ ಈ ಮೂಲಕ ತಿಳಿಯಪಡಿಸುವುದೇನೆಂದರೆ ದಿನಾಂಕ 23/1/2023 ಸುರತ್ಕಲ್ ವಲಯ ಕಚೇರಿಯಲ್ಲಿ ವಲಯ ಆಯುಕ್ತರು ಹಾಗೂ ಸಹಾಯಕ ನಗರ ಯೋಜನಾಧಿಕಾರಿ ಅವರ ಸಮ್ಮುಖದಲ್ಲಿ ಸತ್ರಿ ಆಕ್ಷೇಪಿಸಿದ ಕಟ್ಟಡ ಕಾಮಗಾರಿಯನ್ನು ಸ್ಥಗಿತಗೊಳಿಸುವಂತೆ ಸೂಚಿಸಲಾಗಿತ್ತು ಸಹ ನೀವು ಪುನಃ ಕಟ್ಟಡ ಕಾಮಗಾರಿಯನ್ನು ನಡೆಸುತ್ತಿರುವುದು ಕಂಡು ಬಂದಿರುವುದರಿಂದ ಈ ನೋಟಿಸ್ ತಲುಪಿದ ಕೂಡಲೇ ಕಾಮಗಾರಿಯನ್ನು ಸ್ಥಗಿತಗೊಳಿಸಿ ತಪ್ಪಿದಲ್ಲಿ 1990 ನಿಮ್ಮ ಪರವಾನಗಿಯನ್ನು ರದ್ದುಪಡಿಸಲಾಗುವುದು. This is annexure A. Now kindly come to annexure B. This order came to be passed on my lords 31/2023 annexure A. By then this DC order was not there. Now to annexure B. That is on 17/6. ಪ್ರಸ್ತುತ ಉಲ್ಲೇಖ 4ರಂತೆ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಮಂಗಳೂರು ಇವರಿಂದ ಕುಳಾಯಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 75 ಸ್ಥಳದ ಪೈಕಿ 25 ಎಕರೆ ಸ್ಥಳವನ್ನು ಗ್ರಾಮ ಸಂಘಕ್ಕೆ ಹಾಗೂ ಉಳಿದ 13 ಎಕರೆ ಸ್ಥಳವನ್ನು ಪೂರ್ವದ ಮತ್ತು ಪಶ್ಚಿಮದ ಬದಿಯ ರಸ್ತೆಗಳನ್ನು 12 ಅಡಿ ಅಗಲ ಮಾಡುವ ಸಲುವಾಗಿ ಸಾರ್ವಜನಿಕ ರಸ್ತೆ ಉದ್ದೇಶಕ್ಕಾಗಿ ಕಾಯ್ದಿರಿಸುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಆದರೆ ತಾವು ಕಟ್ಟಡ ಪರವಾನಗಿ ಪಡೆಯುವ ಸಂದರ್ಭದಲ್ಲಿ ತೋರಿಸಲಾದ ಗ್ರಾಮ ಸಂಘದ ಹಿಂಭಾಗದ ರಸ್ತೆ ಇರುವುದು ಕಂಡು ಬರುವುದಿಲ್ಲ. This is pursuant to modification order. ಆದ್ದರಿಂದ ಸದರಿ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿ ಶ್ರೀ ಸ್ವಯಂಸು ಗ್ರಾಮದ ಸಂಘದ ಹಿಂಭಾಗ ಕುಳಾಯಿಯವರಿಗೆ ಈ ಮೂಲಕ ತಿಳಿಯಪಡಿಸುವುದೇನೆಂದರೆ ತಾವು ಮುಂದಿನ ಆದೇಶದವರೆಗೆ ಕಟ್ಟಡ ಕಾಮಗಾರಿಯನ್ನು ಸ್ಥಗಿತಗೊಳಿಸುವಂತೆ ಈ ಮೂಲಕ ತಿಳಿಸಲಾಗಿದೆ. After bifurcation of this property, this order passed by the bifurcation order passed by the deputy commissioner, this notice has been issued.
Are you part of this 38 cents?
No, I am.
You are out of this 38 cents. You are out of this 38.
38 cents. Our education ಏನಂತ ನಾನು ಈ ರೋಡ್ ಎಕ್ಸಿಸ್ಟೆನ್ಸ್ ಇಲ್ಲದೆ ಇರುವ ರೋಡ್ ಅನ್ನು ತೋರಿಸಿ.
Let us hear them. Don't construct anything until then.
In this season, I have already completed my lord's.
If it is not there, it will have to get demolished, Mr. Rashid.
I'm ready to take that risk also.
And you know we'll demolish it. You know we'll order for demolition.
If it is not there. Even if I have committed any wrong.
Why do you want to take the risk? Let them. Where's Mr. Bandari? When will he come back? When will he come back?
Next week, any day, but until Monday and Tuesday, any day.
ಹೇಳೋದು.
ನನಗೆ ಎಂಟ್ರಿ ಮಾಡೋದು.
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 5 ಏನಾಗಿದೆ ಇವಾಗ?
ಗ್ರಾಮ ಸಂಘ ಇಶ್ಯೂ ಆಗಿದೆ.
ದೋಸ್ ಕಟ್ಟಿಲ್ಲ ನೀವು. ನಾನ್ ಫರ್ನಿಶಿಂಗ್ ಅಂತಿದೆ.
Very next day I have paid this.
Yesterday.
27th, 28th.
Issue notice since counsel for the petitioner submitted process fee has been paid for respond number 5. Issue emergent notice for respond number 5 returnable by 22nd August. The registry is directed to place the postal tax report and report.
Serial number 8.
Sorry?
In this case, election process, they issued current payment fixing the election 78. My condition is from the beginning of the it will have started in for 2 years, they have not backward BCM, BJP, they have not given a lot of seats.
Come after the calendar of events has been issued.
Pardon?
You come after the calendar of events has been issued.
Yes, sir. Currently, as per
Vaishali Hegde is directed to accept notice for respond number 1 and the CDP accept notice for respond number 2. Petitioner is before this court seeking for you asking for what? Seeking for the following reviews. The grievance of the petitioner is that from year 1993 for the Goldalli Gram Panchayat, no reservation has been made for the post of president for BCMA or BCMB category. since the calendar of events is already been issued and this election is scheduled on 7th, I am of the considered opinion that the petition is belated and cannot be entertained at this stage.
This was subject to result of the petition, notice may be kindly given at the past.
Notice ಆಯ್ತು.
Huh?
Notice ಆಯ್ತು. You have directed them to take notice and then dismissing.
No, subject to result of, because one should kindly.
What can we do? We can't do
Even
anything.
you will have to kindly see that. It is a true old for the 17 years. We have not put a result for the DCMB and DCMB.
Election is on Monday. You are now on Friday.
Yes, sir.
How can you do this?
Well, let the result be go on, that is subject to result of the
We are
petition.
dismissing your petition, Mr. Chief. We have dismissed your petition.
Yeah, yes, no, you're exactly, but
You should have come a little earlier.
but at least when I let them consider our representation on the second.
What is the point in considering now? Calendar of events ಆಯ್ತು.
At least next academic.
Calendar events ಆಯ್ತು, nomination ಆಯ್ತು, ಇವಾಗ ಎಲ್ಲ ಪ್ರಿಂಟ್ ಆಗೋಗಿದೆ.
At least it may help our next academic.
Next time you have to be more
Cautious.
cautious ಅಲ್ಲ, more next time.
During our AS, number 9, SB Lakshmi.
Please vote.
So I was sick at my office, but it was not collected to make sufficient. On that day, the third respondent made a sufficient, the third respondent is no more.
Third respondent is no more, right?
Third respondent is no more, my lord. Accordingly, my case came to be dismissed, my lord. Then I tried more applications to recall the application 18 to the people and to bring the loss of the third respondent, my lord. So other side, third respondent had been served the,
So you have ended appearance for 3A2. Any objections to allowing this?
so many times they have taken my.
The 17 month. While order dated 18/4/2022,
2022.
this court had granted 2 weeks' time to the petitioner to take necessary steps to bring the legal representative deceased respond number 3 on record and passed a preemptive order that if needful is not done, the petition will stand dismissed. Since needful was not done, the entire petition stood dismissed. As such, now the petitioner has filed IA 1 of 22 for recalling the order, IA 2 of 22 for conviction of delay. Of just to delay 11 days in filing an application to bring legal representative of deceased respond number 3 on record, IA 3 for setting aside abatement, and IA 4 to bring the said legal representatives on record. Notice having been ordered has been served and Mrs. Vidya S. has entered appearance for respond number 3A to 3D. Considering that the applications for bringing legal representatives has been filed, the order dated 18/4/2022 is recalled. By allowing IA 1 of 2022, the petition is restored to file. The right to sue surviving the delay of 11 days in filing IA 2 of 2022 is condoned. IA 2 of 2022 is allowed. As such, by allowing IA 3 of 22, the abatement is set aside. The persons named in IA number 4 of 2022 are brought on record as respond number 3A to 3D by allowing IA 4 of 2022. Counsel for the petitioner to carry out necessary amendments and file amended fast act released on 23rd August. R2 ಯಾರು? ದೇವರಾಜ
Chandramohan was appearing my lord.
So ಯಾರು ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಯಾರು?
I take steps to it once again, please.
ಮಂಜುಳಾ BS ಮಂಜುನಾಥ್. So BS ಮಂಜುನಾಥ್ ಯಾರಮ್ಮ ದೇವನಹಳ್ಳಿ? ದೇವರಾಜ್ ಅವರ ಯಾರು? ಟೌನ್ ಮುನ್ಸಿಪಾಲಿಟಿ ದೇವನಹಳ್ಳಿ ಯಾರು? ವಿಜಯಪುರ. ವಿಜಯಪುರ ಯಾರು? ನೀವೇ ತಗೊಳ್ತೀರಾ? ಯಾರು? ಶ್ರೀ ಸೋನ್ಸಾ is directed to accept notice for respond number 2. In respond number 4 memo of retirement ಇದೆ. Mr. Subbareddy has filed a memo of retirement. Junior ಯಾರು ಬರ್ತಾ ಇಲ್ಲ. Just please take part here. Memo of retirement dated 16/3/2023 has been filed by the council for respond number 4, stating that the files have been handed over to respond number 4 along with no additional wakalatnama. The said memo of retirement is also signed by respond number 4. Accepting the said memo of retirement, Shri K.M. Subbareddy is discharged from the matter. Registry is directed to delete his name. So no representation has been made on behalf of respond number 4. The registry is directed to print the name of respond number 4 in the cause list. With the endorsement served. Lots of R4. Muhammad Shafiullah. During pendency of the above matter, respond number 4 expired. As such, IA 1 of 21 has been filed for condemnation below 174 days. IA 2 of 21 for setting aside abatement, and IA 3 of 21 to bring the legal heirs of deceased respond number 4. Accepting the reasons stated in support of IA 1 of 2021, the same is allowed. Delay of 174 days is condoned. IA 1 of 2021 is allowed. Consequently, IA 221 is allowed. Abatement in respect of respond number 4 is set aside. By allowing IA number 3 of 2021, the person in therein are brought on record as respond number 4A to E. Counsel for the petitioner to carry out necessary amendment and file amended cost title. Released on the objection Akira. Deviation. Released on 28/8.
Number 11.
My loss, I appear for the petitioners in this.
Yes.
My loss, out of 27 petitioners to whom they have issued the impugned notice cancelling their contract, we have produced, my loss. In case of the others, my loss, the department has issued the notice through WhatsApp. We have produced the copy, but we could not take the hard copy and produce it. My loss, it may not be necessary because except for the change in the name, the notices are in verbatim the same for everyone.
You received instruction? That word. HDMC ಇದೆಲ್ಲ Mr. Vijayanath.
Yes, my lord.
You're seeking for relief against Hubli Dharwad Municipal Corporation.
Yes, my lords, and we have also challenged one recruitment rules, my lords, which are the what is this recruitment of Parva Karmika rules we have challenged in this petition, under which they have recruited the Parva Karmikas working under these contractors directly into the department without following the procedure. They too have filed the petition in which there is a stay granted.
Answering respondents are the deputy commissioner, commissioner of HDMC and executive engineer of HDMC.
Yes, yes.
To file this in Dharwad, not here.
My lords, by virtue of a division bench order, my lords, it can be filed here also, my lords. Even for those matters pertaining to Hubli Dharwad or Gulbarga jurisdiction, it can be
for us. You may not be. Then there's no point in having those two benches. Everything can be filed here.
No, this question arose in this very same petition.
Judgment before us. When will you face it?
2:30.
Pass over.
It may be called at 2:30, my lords. I'll tell the side.
Number 12.
Ready, Mr. Naik? In dispensation and Kalidira.
Presentation of notices not issued by the Gram Panchayat as well as assistant
Annexures.
annexures, A notes, A9, A12.
Any objection, Mr. Naik?
My lord, they are looking for a, we have invested, the instruction I am making submission that my lord, investors, my lord, most of the petitioners have got the tender in the best tender also. The parcel lots. The Gram Panchayat note itself says that these premises are in the road margin and ask the petitioners to vacate without conducting inquiry based on the letter issued by the executive engineer. Then you know they want to conduct a fresh tender on the very same premises. It's a contradictory. Public road, somebody has made a complaint that they have entered the public property. The estate executive of the public road department issued a notice for the they have sent a letter to us all. They have intimated. In the meanwhile, they have already informed us that unless survey is done, they can auction the property, they can have the.
It can't be done like that. Either you make your stand clear whether it's encroachment on the road or not encroachment.
We have things that is not enforcement. It is notice issued by the PW department, that is a.
So PWD is a party?
Yes, how to act then? So they are working from us, till we decide, if you can.
Yes.
For a fresh tender.
Mr. Kiran Kumar, is it an encroachment or not an encroachment?
Now they have sent it for survey, my lord. Unless survey is done, my lord, it cannot be decided.
Who has sent it for survey? Yaar there? Who has sent it for survey?
Now, PWD department, they already informed that unless they make survey and.
Ella orally informed.
Because petitioners also getting with this, my lord, we are also getting some license fee. That's the only reason, my lord, we decided.
That is why both of you are together and now putting your PWD out.
Somebody has given a complaint to Lokaयुcta, in view of that, my lord, they issued a letter to the petitioner.
Complaints to be filed, but before you take action, you have to verify if the complaint is right or not.
The PWD department, they will verify, my lord. They have.
Very letter mail, you will act on everything. In on letter, very. All property product PWD department.
Simply they have issued a letter and kept quiet. They are not taken in. Anyway.
Accepting the reasons stated in support of IA 1 of 2021, the same is allowed. Production of annexes A.
A1
1 to A8, A10 to 12, 14, 15, 17, and 18 are dispensed with.
So far, the petitioner 10 to 18 are concerned, may not, they cannot maintain inscription because we are not issued any license to them.
You file your Ashok Naik 6 and is granted 2 weeks time to file a statement of objection. That SCGP 6 and is granted 2 weeks time to ascertain if a survey has been carried out and if survey has been carried out to produce the survey report. Released on 30th.
13. Is that Muralidhar?
For the petitioner, it got the order passed by the. my lord.
Town Municipal Council Kunigal Yaro. Kunigal Yaro. Kunigal. A. Nagarajappa is directed to accept notice for respond number 2, counsel for the petitioner to serve copy of the petitioner along with annexures on the said council. Relist on 28. 28. There's a problem that we have in all matters where they get served, but nobody appears. That's why we are catching hold of the standing councils. We get no assistance at all when they are not there.
Serial number 14.
Another way of demanding.
Pinchana MI has entered appearance for respondent number 1, 2, 3, delete the name of H. Devendrappa and V. Srinidhi as that appearing for respondent number 1, 2, 3. Ready? Objection in ಬೇಕಾಗಿಲ್ಲ ನೀವು submission ಮಾಡಿದ್ರೆ ಸಾಕು. Only assistance we require. If you are ready. And what is this matter, Mr. Kumar?
They had given a demand notice for recovery of taxes. We paid the taxes. Once again, on pending this writ petition on 26/7/2023, they call upon us to pay additional taxes. There is no assessment made. These are all self-assessment. But when we make self-assessment, they have to make some assessment as to how they have arrived at the figures. But our figures will have to be accepted by them. They don't accept our figures. They give us some other figures of the calculations made. But absolutely no calculations are given. They go on issuing show cause notice and recover the amount.
Where is that?
But now by amendment, I am seeking these three documents that are filed at annexure G. Each floor, they call upon us to pay 22 lakhs, 58,690. Then 43 lakhs, 93,585.
There's amendment application pending.
By an amendment application.
So that still has to be allowed.
Yes, but that has to be allowed. But if that is allowed, at least they must give us some assessment how they have arrived at.
Once we allow it, then
Yes, sir.
the process has to happen. The application is still there. IA 1 of 2023 has been filed to bring on certain record certain facts as also seek for prayers relating to washing of demand notice issued by respondent number 3, considering that the same are relevant for completely and effectively adjudicating a dispute between the parties. IA 1 of 2023 is allowed. Counsel for the petitioner is directed to carry out necessary amendment and file amended petition. Relist on 29th.
Then some coercive actions are taken.
Until
They go to the grievances, make an immense, but tenants are in occupation.
it's only a notice. Inner finding agilla.
Even then, take the notice, go to the tenant. But they go on disturbing the tenants.
They have time to go on disturbing the tenant.
They have the time, but the reason are not known. I don't want to explain the reason. But let them not take any coercive action.
It's on 29th only. Let's take.
Please. I'll do that. I'll give a calculation. I said I
Actually, copy they've already given along with the essays. SASL, each item is there to be entered. For you to ask them the calculation may not be proper. Minimum calculation per day. So what are you vacating stay?
Vacating stay. In fact, ಏನಾಗಿದೆ ಅಂದ್ರೆ
Vacating stay ಬಿಟ್ಬಿಡಿ.
ಅಲ್ಲ, ಒಂದು ನಿಮಿಷ.
Main matter argument.
ಇವತ್ತಾಗುತ್ತೆ.
ಯಾವತ್ತಾಗತ್ತೆ?
Next week ಯಾವಾಗ?
Next week ಯಾವತ್ತಾಗತ್ತೆ?
ಯಾವ ಡೇಟ್ ಇದಾದ್ರೂ ಮಾಡ್ತೀವಿ.
15. Then it council for since consideration of IA 1 of 22 for vacating stay would amount to consideration of the matter on merits. Relist on 9th. 9th.
Next week.
Next week is like the 9th.
ಆಟೋಮೇಟಿಕ್ ಇದೆಯಲ್ಲ, ಅದು ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲ, ಅದು ಇಶ್ಯೂಸ್ ಬೇರೆ. ಅದು ಈಗ ಆಲ್ರೆಡಿ ತಾವು ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ರಿ, ಅದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಇಶ್ಯೂ ಆಲ್ ಟುಗೆದರ್ ಡಿಫರೆಂಟ್. ಸೇಮ್ ಇಲ್ಲ, ಸೇಮ್ ಮುನ್ಸಿಪಾಲಿಟಿ, ಬಟ್ ಆ ಕೇಸ್ ಒಳಗೆ ಅವರು ಟ್ರೀಟ್ಮೆಂಟ್
ನೀವು ಅವತ್ತು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇರ್ತೀರಲ್ಲ, ಅವತ್ತು ನೋಡೋಣ. If it is different, we'll dealing.
ಅದನ್ನು ಇದ್ರ ಜೊತೆ ತಗೋತೀನಿ. ಸರಿ,
ಆಗೋಗಿದೆ. ಅವತ್ತು ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದಾಗ ನೋಡೋಣ ಡೀಲಿಂಗ್ ಮಾಡ್ಬೇಕೋ ಬೇಡವಾ.
ಈಗ ನಂಬರ್ 16 Rajuddin. And
17.
70.
So that also will have to be adjourned.
Also could be taken together, but this is Sidmalappa is not there.
Mr. Sidmalappa? Oh, this is that, shop.
They have locked it.
Where,
Doesn't matter, this was.
has it been locked?
They have voluntarily given up. No, not voluntarily given up, but I already argued. They are part of the department, they are not the other.
We'll hear your argument once and for all.
Peaceful argument. Our head and
Mr. Sidmalappa? Once it reaches, he's there, but it's. Yes.
Please, Madam.
Sidmalappa, in serial number 70, your 15
Madam.
and 70 are connected and that.
Please, my lord.
15 and nimdu 70th matter are connected.
Please,
Mr.
Madam.
Hegde wants it on next week, so we'll take your
Okay.
matter also on that day,
Please.
on 9th, in serial number 70. Connect with stones.
Number 15, I got the, my lord, I am for the petitioner.
Yes.
I filed the amendment petition. And I have also filed the reply statement to their objections. That has not been corrected. Amendment petition.
Yesterday you filed an application. You have filed an application for amendment.
Amendment. Up to amend the prayer. That license.
It's the amendment application that they have filed,
Yes.
which has not been put up. Pass over, we'll ask, that's it. Bandi diya. You've been served with the copy, Mr. Ramesh?
Yes, sir.
You'll allow it? IA 2 of 2023 has been filed, seeking for placing on record certain additional facts and additional prayer in view of the contention of respondent number 1 to 4 that a license has been issued by them to respondent number 5. The said amendment having arisen on account of the subsequent information being furnished and the amendment being necessary to properly and effectively adjudicate the dispute between the parties, I allow the said amendment, said application in IA 2 of 2023, counsel for the petitioner to carry out amendment and file amended petition, serving copy thereof on the other respondents. But now we'll have to issue notice to respond number 5. Sorry, one minute. Since there's a new prayer that you are seeking for, is only served. I issue notice on IA 2 of 2023 to respond number 5, returnable by 14/9.
Not because receiving the notice, my lord.
Madam, if you file an application seeking for fresh relief, you have to issue a notice. If you want to take out hands, you can take out hands.
So paper publication for the last, paper publication is purposely,
You
and
can-
notice also.
Is there in the shop, is your license?
And notice.
So you serve it on it. Respond number 1 to 4 are directed to serve. The notice on respond number 5. Registry is directed to furnish the notice to Sri N.K. Ramesh. We can't refuse you. Jaglur Town. Jaglur. Is directed to accept notice for respond number 4. And what is the mandamus?
The petitioner's land comes under the commercial zone as per annexure G and G1. And I obtained the license to open the petrol bunk.
Application is still pending.
My application is still pending. As per the master plan of the Jaglur, my land is comes under the commercial zone. And also I obtained the license from the company.
We are not concerned about that for now. When did you make the application?
Lord, application at annexure 12/9/2022 and subsequently 2/3/2022 and 4/3/2022.
Online ilva?
A1, A2.
Online ilva application.
ಇದು ಸ್ವಲ್ಪ ನಾನು ಬೈ ಹ್ಯಾಂಡ್ ಕೊಟ್ಬಿಟ್ಟು
Online ಇದೆಯೋ ಇಲ್ವೋ?
ಆನ್ಲೈನ್ ಅಲ್ಲಿ ನಾವು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಬೇಕು ನಮಗೆ ಬೈ ಹ್ಯಾಂಡ್ ಆನ್ಲೈನ್ ಅಲ್ಲಿ
ಎಲ್ಲ CLU change of land use ಎಲ್ಲ online.
they are
You will
not
get the information immediately whether it's accepted or not.
it is not in the online, they are taken in the by hand only. And only to permit me to open the petrol bank, since
Serve it on Mr. Mahesh. Relist on 21st.
covered by the statement of.
Serve it on Mr. Mahesh. Hmm?
Not pay for, the enclosed is some portion of the land of the petitioner.
Survey application ಹಾಕಿದ್ದೀರಾ?
Actually, annexure is the,
Annexure.
annexure, he is the representation.
Representation application file ಮಾಡಬೇಕಲ್ಲ.
In 2015 ಅಲ್ಲಿ
Survey you have to file application, make payment of necessary fees for it. Representation ಕೊಟ್ರೆ ಆಗಲ್ಲ.
15 ಅಲ್ಲಿ online application. I made a permitted.
We will permit you to do that, and now it is online, but even then it was fees has to be paid. Otherwise we can't do it.
The direction.
If Pawan Kumar accept notice for respond number 1 to 3, petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that though an application has been filed by the petitioner though a representation being submitted by the petitioner for carrying out a survey and removal of encroachment, the same was not acted by the respondents, in furtherance of which a representation had been furnished on 15/10/2022, which has also not been acted upon. Since the petitioner seeks for a survey of the property, it is required for the petitioner to file necessary application under the appropriate in the appropriate form, now provided online, by making payment of necessary fees, which would be required to be acted upon by the respondent. As such, I pass the following order. Writ petition is allowed in part. Petitioner is permitted to file necessary application for survey by making payment of necessary fees, which shall be considered and acted upon by the respondent within 15 days of such application, within 30 days from the date on which, from the filing, date of the filing of the application.
18. 50 and then other.
This would keep
Unapproved by the Karnataka Development Authority.
carrying the plan to
Planning authority.
respond number 4.
Number 4 is the advertising company. Advertise the layout. Respond number 3 is the developer. Respond number 2 is the authority. Karnataka Development.
Near nim ground end.
I have booked a site through the advertisement of the advertiser. The site number at page number. Site book ಮಾಡಿದ್ವಿ ಅದರಲ್ಲಿ ಎರಡು ಐಸೋಲೇಟೆಡ್ ಲೇಔಟ್ ಪೇಜ್ ನಂಬರ್ 14 ನಲ್ಲಿ ಎರಡು ಐಸೋಲೇಟೆಡ್ ಲೇಔಟ್ ನಲ್ಲಿ ರೋಡೇ ಇಲ್ಲ, ಅಲ್ಲಿ ರೋಡ್ ಮಾಡಿದ್ದಾರೆ ಫಿಸಿಕಲ್. ಯಾವಾಗ ಎಂಟ್ರಿ ಆಗ್ತಿರೋ ಅಲ್ಲಿ they will file a criminal case after booking. The planning authority, without looking that these two chunks of land were connected through the road, has given an approval. The road is clearly seen in the advertisement furnished by the future at page number 24. Book ಮಾಡಿದ ನಾನು ₹1,00,000 ದುಡ್ಡು ಕೊಟ್ಟೆ. ದುಡ್ಡು ಕೊಟ್ಟಾದ್ಮೇಲೆ ಅವರು
ಇದು ಪ್ಲಾನ್ ಅಲ್ಲ, ಇದು
ಪ್ಲಾನ್ ಅಲ್ಲ. 14 is the plan. 14 is the.
So you are a You are a lawyer, you are a person who wants to buy a site.
By a site. In the second.
And your contention is that the plan is not given properly.
Not properly approved.
Where are go back ನೀವು?
ರೇರಾದಲ್ಲಿ ನೋಡಿದ್ರು ಸಮೇತ ಇದೆ ಇದನ್ನೇ ಅಪ್ರೂವ್.
ಅಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು to seek for redressal.
My lord,
You can't come here to ask for plan sanction to be
no, I
cancelled.
am not asking for a plan sanction. Plan sanction itself is an illegal because there is no link of the road itself and they have approved the plan.
So that you have to go before the RERA.
ರೇರಾಗಿನ ಸಮೇತ ನನ್ನ ಅದನ್ನು ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಅಂತ ಅದನ್ನು RTI ಅಂತ ಅದರಲ್ಲೂ ಸಮೇತ ನಾನು ನೋಡಿಲ್ಲ.
Road ಇಲ್ಲ ಅಂತಾನೆ ಒಪ್ಪೋಣ. You are coming and asking for cancellation of a license on the ground that
Cancellation of license, cancellation of approval by the planning authority. Yes.
first approval ಆಮೇಲೆ license ತಾನೆ ಕೊಡೋದು, work order ಕೊಟ್ಟಿರ್ತಾರೆ. You are asking for those cancellation. You have to go before RERA, not before this one.
No, I am not claiming damage only. The damages occurred only for the mental harassment and it is also they have also tortured me for giving me 1 lakh rupees which was already advanced for them. The approval is given by the Kanakpura Development
You
Authority.
won't stay anything. The CDP accept notice for respond number 1. Kanakpura Yogesh Yadav accept notice for respond number 2. Uttaralli MS Devraj accept notice for respond number 5. Issue notice to emergent notice to 3 and 4 returnable by 11th September.
Serial number 20, moving years.
The G may not states that the is the internal order passed by the technical at this point. Which not on the basis of the request that to be made by the members of the town panchayat, but the property in question not which is under the ownership and possession of the traditional Gram Panchayat is now sought to be taken back. And even not without the notice and even without marking the copy of this. When they see in order to accept page 34.
34.
Page 34.
Yes. Now your Gram Panchayat does not exist. It's become Patan Panchayat.
Has become Patan Panchayat, but still not the Gram Panchayat is still in existence.
How can it be in existence after Patan Panchayat comes?
But the election is held not where the elected representatives of the Panchayat. It is still still operational. Maybe not part of the area not is transformed into a Patan Panchayat.
Is full Gram Panchayat is being transferred to the Patan Panchayat?
No.
Only part.
Part.
So the part that is transferred, is that where this property comes?
Not even assuming not that property comes there, not it doesn't not automatically go to them.
It does.
Without there being an inquiry, not.
No inquiry is required. If suppose total 1 to 10, one panchayat with ನಿಮ್ದು 9 ಅಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕಲ್ಲ ಆ ಏರಿಯಾ ಅಲ್ಲಿ
ಅಲ್ಲ ಆದ್ರೂ kindly see my lord there is a reference my lord to our name my lord in the impugned order.
There will be all the assets and liabilities of the panchayat in regard to transferred area will go to the Patan Panchayat.
Not 355A my lord there is part of which my lord will be.
Whichever area land area demarcation ಇದೆ ಅಲ್ಲ.
There is no reference, that is one aspect my lord. ಯಾವಾಗಾಗಿದೆ ಏನಾಗಿದೆ ಅನ್ನೋದು there is no reference in the order. One order my lord of this honorable court.
When was the Patan Panchayat formed? 355. When was the Patan Panchayat formed?
But that is not mentioned anywhere. There was an earlier proposal not on 4/11/2006 by 2 notifications. Not that was said to be withdrawn not by the government. It's said to be that order only now.
CGP accepts notice for respond number 1 and 2. Shivamoga yaru? Shivamoga. Shivamoga yaru? MR? Patil is directed to accept notice for 3, 4 and 5.
4 and 5 is.
3, Ms. Somyaji for 4 and 5. Counsel for the petition, serve copies of the petition along with annexures and said counsel. Released on 22nd August.
Let us go.
It's the government will be the button puncher just get no case. We only want their submission on that.
PDO on the other, who is looking after our press. But for reasons.
Once the line is drawn, everything in this will go here. If it is here, then it will be with you.
There is no reference for that, and there is an earlier order of this honorable court. When the town panchayat said that they have withdrawn the government said that withdrawn both the notifications. Probably will not have no notifications. That will not take up.
The order itself says there is a button puncher.
Please.
Manivandan? $321 ಆಗೋಗಿದೆ. Not served. Password. Yes. None appears for the petitioner. Counsel for respond number 1 and 2. Shri Ashwin Aladi has entered a case for 1 and 2. Delete Pawan Kumar. None appears for the petitioner. Shri Aladi requests for and is granted 2 weeks time. File a statement of objection. Objection penny by 24th. Released on 29.
23, Vishnu Kumar.
Challenge ಇಲ್ಲ ಪಾಪ mandamus ಕೇಳಿದ್ದೀರಾ?
Challenge investment data 25/5/2022 issued the respond number 2 and same is my even investment data 24/11/2022 issued the respond number 2 that is annexed A and B.
Challenge ಮಾಡಕ್ಕೆ issue mandamus washing ಅಂತ ಹಾಕಿದೆ. DG accepts notice for respond number 1. SCP accept notice for 1 and 2. Anekal, Chandapura Municipal Council. Kemperna accept notice for respond number 3. Council for the petition serve copies on said council released on 29. Yes.
And they are different companies depend upon agriculture. And they have invested money in agriculture property. My lord, respondent number 4 has passed a resolution and decided to reserve a land for a material recovery facility unit, my lord. Where respondent number 3 has passed an order for reserving the land for the same, my lord. But my lord, the annexed yes, my lord, page number 55.
What is material recovery facility ಅಂದ್ರೆ ಏನದು? ಏನ್ ಮಾಡಿ
ಡ್ರೈ ವೇಸ್ಟ್ ಅದನ್ನ ಒಂದು ಸ್ಟಾಕ್ ಮಾಡಿ ಅದನ್ನ ರಿಯೂಸ್ ಮಾಡ್ಲಿಕ್ಕೋಸ್ಕರ ಪ್ಲಾಂಟ್ ರೆಡಿ ಮಾಡಿರ್ತಾರೆ ಗವರ್ಮೆಂಟ್ ಅಂದ್ರೆ ಸರ್ಕಾರದ.
ಸೊ ಅದಕ್ಕೆ ರಿಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ ಇವಾಗ.
ರಿಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ. ಆದ್ರೆ ಏನಾಗಿರುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರೆ ಎನೆಕ್ಷನ್ ಎಚ್ ಪ್ರಕಾರ ಗಂಜಿ ಮಠ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಏರಿಯಾದಲ್ಲಿ ರಿಸರ್ವ್ ಮಾಡಿರ್ತಾರೆ. ಬಟ್ ಲೋಕಲ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಂದ ಈ ಪ್ರಾಜೆಕ್ಟ್ ಅನ್ನ ಗಂಜಿ ಮಠದಿಂದ
ಶಿಫ್ಟ್ ಮಾಡಿರ್ತಾರೆ ಡೇಟಾ ಬದಲಾಗುತ್ತೆ.
ಬೇರೆ ಯಾವ್ದಾದ್ರು ಲ್ಯಾಂಡ್ ಕೊಡಿ, ನೀವು ಐಡೆಂಟಿಫೈ ಮಾಡಿ ಒಂದು ಲ್ಯಾಂಡ್ ಕೊಡಿ, ಅಲ್ಲಿ ಶಿಫ್ಟ್ ಮಾಡೋಣ. ಯಾರು ಬೇಡ ಅಂದ್ರೆ ನಿಮ್ ಮನೆಯಲ್ಲೇ ಮಾಡ್ಬೇಕಾಗತ್ತೆ.
ಇದರಿಂದ ಏನಾಗುತ್ತೆ ಅಲ್ಲಿ ಪಕ್ಕದ ಸ್ಕೂಲ್ಸ್ ಅಲ್ಲಿ ಇದೆ ನೀವು, ಹಾಗೂ ಲೇಕ್ ಇದೆ. ಮತ್ತೆ ಈ ಸ್ಥಳ ಏನಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ನಮ್ಮ ಲ್ಯಾಂಡ್ ಇಂದ ಎತ್ತರ ಪ್ರದೇಶದಲ್ಲಿದೆ. ಸೊ ಅದರಿಂದ ನೀರು ಬಂದಿದ್ದು ನಮ್ಮ ವೆಲ್ ಮತ್ತೆ ಲೇಕ್ ಎಲ್ಲ ಹೋಗುತ್ತೆ ನಮಗೆ.
And SCGP accepts notice for respond number 1 to 4. Dhananjay Shetty accepts notice for 5 and 6. ಯಾರು ಇವಾಗ ಇದು ಮಾಡ್ತಾ ಇರೋದು? Respond number 5.
Respond number 3.
Respond number 5 has passed the resolution for the.
Yes, but order was passed by the respondent number 3.
Please find out if you have taken all the environment clearances.
Upon that, we have filed RTI. Even Panchayat has no information regarding this.
Have you obtained any environment clearances? Location study, feasibility study, the CGP is direct placed on record. Any environment clearance is obtained, as also a feasibility study conducted in respect of the property in question. Released on 29.
25. They were
Yesterday, in the petition number 25,791, this court had directed to list this case also along with that case. And then posted for 21(8).
So before that order could go, this is connect the above matter with WP number
25,791 of 22.
and relist on
21(8).
21(8).
Much of it.
26. Serial number 26.
Yes.
Dismissing the appeal filed under section 113 of the GLC Act. Petitioner is a PSU, my lord.
Sure.
In the year from 2004 onwards, my lord, the year 2004 will be declared as a Sikh industrial company, my lord, under the Sikh industrial company act.
You have to pay your tax whether you are PSU or Sikh or whatever.
No, my lord, my only grievance is, my lord, is the finding, my lord, there's a finding. They have not approached under section 22, my lord, of the act. They have not taken permission from the BIFR before taking any course.
BFI is no longer there now.
It's no longer there, my lord, but this happened in the year 2018, my lord. The notification and challenge is in 2018. And then also, my lord, there's a finding that clearly states that they based.
Pawan Kumar is accepts notice for respond number 1 and 2. Counsel for the petition serve copies of the petition along with annexes on the said council. Relist on 29.
27. Srinivas Babu.
Plan sanction, date number 39.
Who is constructing the road?
Some respondent 7 is a private contractor. He has taken the contract with regard to construction. And without having any prior approval or any direction, he is constructing the road. And it is in violation of the plan sanction. As per the plan, I will construct B. The approved road is different and the road is planning to construct different methods. Affecting the petitioner's property.
Who is directed respond number 7 to, you have directed respond number 7 to form the road? Notice not ordered on respond number 7, is it? Hello? Notice not ordered on respond number 7. You have to order notice. Issue notice to respond number 7, returnable by 12 September. Interim order earlier granted is extended to next day. 2 weeks time is granted to respond number 4 to 6 to file their statement of objections.
They are escalated the road, they have already done.
Instruction told like initially there was no interim order.
Okay.
Prasanna? If you notice to respondents returned by 12 September, Monday, BJ Somyaji accept notice for respond number 3 and 4.
29. Another.
Page number 11.
10.
The land was awarded 2016-17 ಅಲ್ಲಿ ನರೇಗಾ ಅಂಡರ್ ಅಣಕ್ಕೆ ಅಂತ ರಾಗಿ ಮತ್ತೆ ಭತ್ತ ಇದಾಗಲಿಕ್ಕೆ ಅಂತ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ. ಈ ಜಾಗದಲ್ಲಿ ಆಲ್ ಇಂಡಿಯಾ ಡೈರಿ ನಿರ್ಮಿಸಲಿಕ್ಕೆ ಜನರಲ್ ಬಾಡಿ ಮೀಟಿಂಗ್ ಮಾಡಿದ್ರು. ಆಮೇಲೆ 19/3/2022 they made an general assembly. They have passed the resolution. ಇಲ್ಲಿ ಆಲ್ ಇಂಡಿಯಾ ನಿರ್ಮಿಸಬೇಕು ಅಂತ ಆರ್ಡ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು. Before the EO. The EO was passed, status quo order. Status quo order is not. They are made unauthorized construction. I have produced annexed D, page number 16 and 17.
As a house.
House. Next to that, this is the petitioner's house.
Yeah,
Page number 16.
16 Nim house.
Oh.
That's construction.
Oh.
17.
17, 18 now. 18 and 19. Which is very clearly shown. The construction was obstructing my enjoyment.
How is it objecting your enjoyment?
ಅದು ಕಣಕ್ಕೆ ಅಂತ ಯೂಸ್ ಆಗ್ತಿದ್ದಂತ ಜಾಗ ಅಲ್ಲಿ ರಾಗಿ the only land
ನಿಮ್ಮ land ಅಲ್ಲ.
ನಮ್ಮ land ಅಲ್ಲ.
So if that land is used, how can it obstruct you? ಕಣಕ್ಕಾದ್ರೂ ಯೂಸ್ ಮಾಡ್ಲಿ ಇಲ್ಲ ಇದಕ್ಕಾದ್ರೂ ಯೂಸ್ ಮಾಡ್ಲಿ. Your access is from the left side.
Yes.
You can't claim an access through this land.
But ಇದು ರಾಗಿ ಕಣಕ್ಕೆ ಅಂತ ಊರಲ್ಲಿ ಒಂದೇ ಜಾಗ. I am also agriculturist. ನನ್ನ ಜಾಗದಲ್ಲಿ ನಾನು ರಾಗಿ ಬೆಳೆ ಎಲ್ಲ ಒಣಗಾಗಿ ಯೂಸ್ ಮಾಡ್ತೀನಿ ಜಾಗ. There is a lot of
only issuing notice now. So far we find this petition to be an abuse of the process court. Later if we find that, then we will impose exemplary cost on it. Please remember that. SCGP accepts notice for respond number 1 and 2. Ginjigiri, Alur Taluk, Hassan. Mr. Devraj accepts notice for respond number 3 and 4. The Devraj seeks for and is granted 2 weeks time to obtain instruction and make a submission as regards the reservation of the land in question and the use thereof. We list on 28/8.
number 30. Someone gets them.
Petition is arising on the first. Wherein the honorable NCLT and waived of the arrears in property tax. They will take to the respondent.
AARP proceedings.
The petitioner was a successful resolution application
Hmm.
in the CRP proceedings against BJ.
Hmm.
Wherein the asset of BJ motors were transferred into the name of the petitioner.
Hmm.
Simultaneously, the arrears in the property tax were waived off.
You can waive off the arrear
The NCLT, because it was as provided under the resolution.
without the consent of the BBMP.
It was never a part of the.
If BBMP is not a party, how can the NCLT waive of BBMP dues?
The operational, they come up all under the definition of operational.
Where they made party,
Irrespective of whether they are being the party, please not say.
without hearing them, who are there to do that?
Keeping the scheme of the IBC in mind, please not see.
Yes, but they have to be heard.
The NCLT also please not was the committee of creditors have to approve the resolution plan.
Were they heard, Mr. Counsel?
Okay, my humble submission is we must, irrespective of whether we can be heard or not. If once the committee of creditors accepts a resolution plan, wherein all the debts which are either covered or not covered under the CIRP will stand extinguished.
So anybody can pass an order. An order could be passed against anybody by the CIRP without hearing them.
No,
And that will get,
Anybody please not only against the operational creditors. And there.
obviously, when we say anybody is operational creditor, an order could be passed against any operational creditor without hearing them,
Yes,
cancelling their.
that's the scheme, if I
Please
may.
place it on record, we will see that.
Please.
Three, Pawan Kumar accepts notice for respondent. Counsel for the petitioner to serve copy of the petition along with annexures on the said counsel. Relist on learned counsel for the petitioner seeks for and is granted a week's time to place on record the scheme under which the property tax dues to the respondent have been.
Commission was the scheme of IBC, please, there is no separate scheme.
Scheme under which the property tax dues of the BBMP have been cancelled by the CIRP, by the NCLT, without hearing the respondent. We list on 21st.
31, 13 years.
Challenging the order passed by the commissioner. My lords, order is at page number 22. Because in the last portion, my lord, ಕಟ್ಟಡದ ಕಳವಳ ಗುರುತಿಸಿ ಜಂಟಿ ಸರ್ವೆಗೆ the dispute between my lords, petitioner and respondent number 1 and 2, my lord, is before the civil court, my lords, at page number 37, my lords, annexure F, my lords.
Now you have put up in 163 1C or 163 1A 1A2.
My lords, in 161 C, my lords.
Is 163 1A 1A2 part of 163 1C?
No. It is a different property, my lord. I have filed a suit, my lord, for 4/5 share. In 163 1A 1A, my lord. At annexure F, page number 37.
So when that issue is pending, how are you constructing?
My lord,
Without a,
no, my lord. Before that, my lord.
you are seeking for a declaration that you are the owner.
Yes, my lord.
Without the declaration, how are you constructing?
My lord, before that, my lord, I have obtained the conversion order and I have obtained the plan section, my lord, before filing the suit.
Your contention is when a suit is pending, they should not take any
My lord,
action. Your suit itself is to declare yourself as the
my
owner.
lord, my lord, suit insofar as 163, 1A, 1A, my lord. I'm constructing in 1A, 163, 1C, my lord.
Hmm.
My lord, this one I put in similar matter, my lord. Filed by the same petitioner, my lord, has granted an interim order. As for subsequent order passed by the state judge. The same appeal, my lord.
What are you challenging?
Now, my lord, I am challenging the order dated 10/11, my lord. Earlier, my lord, subsequent order, my lord, 28/3/23, I have challenged. Both the petitions.
What was 28.3?
My lord,
What was 28.3 order?
28/3 order is, my lord, the report filed by the survey report filed by the joint surveyor, my lord, has been accepted by the state commissioner, my lord. My lord, my lord, I challenge because both the petitions take kindly, my lord.
Connect the above matter with WP 9001 of 2023 and relist on
Ravisankar Shastri G has accepted notice for R2.
R2 Garo,
Ravisankar Shastri.
Ravishankar Shastri accepts notice for respond number 2. The Sharendra Shetty is right to accept notice for respond number 3 and 4. One again, issue notice to respond number 1, returnable by 13/9, connect with so and so.
32, Kenneth Bird.
Commissioner, we thought for issuance of Yekata in respect of the issue.
There's no interim pay. SCGP accept notice for respond number 1, Pawan Kumar for 2 and 3. Serve copies, relist on 4/9.
33, Rajeshwar Appeal.
Road is already formed. CGP accept notice for respond number 1 and 2. Tumkur error. 1, 2 and 5. 1, 2, 4 and 5. Yeah, yeah. A Nagarajappa for 3. 6 error. Yes, Ravi. Not equal to the petitioner furnish copies. Relist on 6 is also Nagarajappa. A Nagarajappa. Relist on 4th September.
Before CX Siddhamalappa.
Lord, I represent the petition of this.
Yes, Mr. Benaka.
Seeking writ of mandamus, Lord, to consider my representation. Lord, seeking, Lord, change of kata. Lord, annexure, page 16, Lord, my representation. Lord, there was a suit filed, suit is decreed. Even then, Lord, the authorities are not considering my representation.
SCGP accept notice for respond number 1. Ethenalli Gram Panchayat Tumpur. Accept notice for respond number 2. Petitioner is before this court, seeking for the following reliefs. The petitioner claims to the owner of house property bearing number 181, situated at Ethenalli village, Athene Gram Panchayat, Tumkur Taluk. The petitioner having filed a suit in invoice number 805. Is only for permanent injunction, Mr. Sidmalappa.
Lord, the trial court, Lord, accepted my title. Lord, I sought only for a injunction regarding Lord interference by third party.
Khata is in whose name?
Lord, it stands in my name only, Lord. I produced Lord annexure name, Lord, is the
Your Khata transfer kelta idira neevu.
and Khata
Somebody else's name.
E Khata could inte kelta idi. Madlu Khata agide. Adu E Khata, Lord, is a regular Khata. Lord, annexure name, Lord, I have produced the demand register extract where, Lord, my name is found, Lord, as that of owner and occupier.
Page number?
Lord, page number.
Belongs to her husband, late husband Rangaya, and upon his expiry, she succeeded to the property, and her name came to be entered into the revenue records. There being the state having come up with a proposal of issuance of e-Khata, she made an application for issuance of e-Khata, which is not being considered on account of a suit in OS number 805/1997 being pending. Subsequent to the disposal of the said suit in favor of the petitioner once again approached the respondent for issuance of the e-Khata by representation dated 26/12/2022, which is yet to be considered. In that background, the petitioner is before this court. Whenever any application or representation is made by a citizen to a statutory authority, the same is required to be either accepted or rejected by passing reasoned order within a reasonable time. The same not having been done, I pass the following order. The writ petition is allowed, a mandamus is issued, directing respondent to consider the representation of the petitioner dated 26/12/2022 at Annexure D in accordance with law within a period of 30 days from the date of receipt of a copy of this order. It is made clear that this court has not expressed any opinion on the merits of the matter.
For the petitioner, my lordship.
Yes.
My lordship, this is the second round of litigation between the petitioner and the respondents. The respondent number 1 and 2 are the Corporation Authority of Mysore, and the respondent number 3 is my neighbor. My lordship, I have obtained an order as against the respondent number 3 at Annexure A2, page number 22, by this Honorable High Court, directing
page number A2?
Page number 22, my lordship. Yes, my lordship. The respondent number 3 had raised illegal construction, my lordship, on her private property. And then this honorable court had directed the respondent number 1 and 2 to take action as per law under the KMC Act 3 and 321, my lordship.
Geeta Devi Papanna accepts notice for respondent number 1 and 2. Issue notice to respondent number 3, returnable by emergency notice written by 11/9.
Obliged.
Devi Narasimhan.
Narasimhan. Housing board. So H.L. Pradeep Kumar is directed to accept notice for respondent. Counsel for the petitioner to furnish copy of the petition along with annexes on the said grounds is relist on 29.
37.
Just to have passed ballot and the case for the solution. Is my building full building that was never there. Removing and the restoration. The main road of the election days.
Annexure J.
This age, where may not JCB still there. JCB is not for demolition. They were not, then we asked for the demolition order, they were not voting. Demolition order is passed, passing in the name of one Sanjeev. Sanjeev is not connected to this. No minority, minority, of my. The order.
When you sale Delhi, you were purchased it when?
Yes, there is not the next year, my lord. The next year is the 2001, my lord, is in the family property, my lord. Father has given to me, 2001. Then itself, my lord, is the scheduled lots of the in place 17. At that point of time, also, it was there, my lord. In place 17, my lord, schedule 3, item number 1, my lord. Measuring 20 to 30 feet, I think it was spectrum of course. As of that time, it was there.
That day, this building was not there. This building was a building in the Mr. Play. I think in sanction plan told you. Construction plan sanction told
after construction of the building, section 247
it is in accordance with the building bylaws.
according to the building bylaws in the relation. Only thing is they have not obtained sanction.
Pawan Kumar accept notice for respond number 1 and 2. The response are restrained from demolishing the scheduled property. Any construction on the scheduled property. Relist on till the next date, relist on 29/8.
Petition not acquire piece of land. As per annexure A, it is 25 into 25 site along with another triangle shape of 240 square feet of property. And especially personal property paying tax and everything to the BBMP. And share out there because there's an interference from Krishna Swami, she had filed a suit in 2008 and obtained a degree also. And share the increased portion. When this thing at the instigation of the fourth respondent, who is an adjacent site owner or property owner, because she has some weakness in the BBMP. We have issued a notice as per annexure E. That is in 2021. In that, they called upon to produce documents. Petitioner submitted a reply as per annexure F also. And thereafter another notice was issued. The endorsement was issued stating that no work should be done in the property by the BBM. That was questioned by the petitioner by filing request in this honorable court as per annexure H. This honorable court was to allow the petition and said it's a color and exercise to the power by BBMP and allowed the petition as per annexure H. That's at page 80. However, because of the influence both the respondent has the BBMP challenged by filing a writ appeal. That is annexure J. And this honorable division of the honorable court felt that it was a surplus notice
you can type, submit your report. And that's the order page 88. Permitted to submit his reply response to a notice issued by the agency within 4 weeks from today, and they should decide. Accordingly, the petition submitted an reply
Any restraining any construction in the said property pending the resolution of the suit in verse number 5351 and appeal in 383 of 2022.
No, earlier, proportion of.
Your impugned order is Annexa L.
Yes, my lord, 94. It says, ಮೇಲೆ ತಿಳಿಸಲಾದ ಆಪರೇಟಿವ್ ಕೋರ್ಟ್ ಆಧಾರದ ಮೇಲೆ ಪ್ರಸ್ತಾವಿತ ತ್ರಿಕೋನಾತ್ಮಕ 242 ಜಾಗವು ಕೀರ್ತಿಯಲ್ಲಿ ಅವರಿಗೆ ಹಕ್ಕು ಬಂದಿರುವುದಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಪೂರಕ ದಾಖಲೆ ಸಲ್ಲಿಸಲು ವಿಫಲರಾಗಿರುವುದರಿಂದ ಸದರಿ ಜಾಗ ಸಾರ್ವಜನಿಕ ಸ್ವತ್ತಾಗಿರುತ್ತದೆ. How can they claim that it's a public property?
ಆಮೇಲೆ
ಸೆಕ್ಷನ್ 129.
ಆಮೇಲೆ ನೋಡಿ
ಆಮೇಲೆ ಈ ಬಗ್ಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸಿಟಿ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ OS 5351 that is the fourth respondent filed a suit. ಮತ್ತು ಕರ್ನಾಟಕ ಭೂ ಕಬಳಿಕೆ ವಿಶೇಷ ನ್ಯಾಯಾಲಯದ ಸಂಖ್ಯೆ ಐ ಆಮ್ ನಾಟ್ ಅವೇರ್ ಆಫ್ ದಿಸ್ ಪ್ರೊಸೀಡಿಂಗ್. ಪ್ರಕರಣ ಬಾಕಿ ಇರುವುದರಿಂದ ಸದರಿ
you are not party to 383. You are not party to 383.
No, I have not issued any notice from the land grant court.
You are a party or you are not?
Because I did not get any papers on that.
Online ಹೋಗಿ ನೋಡಿ ಚೆಕ್ ಮಾಡಿದ್ರೆ ಸಿಗತ್ತೆ.
Party said he has not issued a notice on that.
ಇವಾಗ ಅದೆಲ್ಲ those grounds are not available.
I am not made I am confessing. I have not taken that.
Any matter you can go on their website and check.
True, I should have done that, but ಇರುವುದರಿಂದ ಸದರಿ ಪ್ರಕರಣ ನ್ಯಾಯಾಲಯದ ತ್ರಿಕೋನಾತ್ಮಕ ಜಾಗದಲ್ಲಿ ರೀತಿಯ ಚಟುವಟಿಕೆ ಕೈಗೊಳ್ಳಲು this is only without jurisdiction.
But how can we stay this now? It is only saying
Declaration that is a public property.
that will consider in merits.
True, under section 129, your last kindly.
We'll have to consider that will get be a final order.
ಅಲ್ಲ,
ಈ ಚಟುವಟಿ ಏನು ಮಾಡಬೇಕು ಬಾಗಿಲ್ಲ ಅಂದ್ರೆ ನಾವು ಸ್ಟೇ ಮಾಡಿದ್ರೆ ಚಟುವಟಿ ಆಗೋಗತ್ತಲ್ಲ.
I am not going to do any work.
Let
I
them-
am the owner of 1998. If I had to, I have done all study. Under section 129,
There's no need to stay it now. We'll hear and dispose the matter. Mr. Pawan Kumar accept notice for respond number 1, 2, 3. Issue notice, emergent notice to respond number 4, returnable by 11th September. Another accept notice for respondent. Petitioner is before this court, list so and so number. Accept notice. 14 42, 43, 39, 40, 42, 43.
41, Vinod Kumar.
For the petition of demolition order is passed without issuing notice to me.
Demolition order is passed without notice. 60?
6 months. My friend asked me to COVID time.
You are Jabin Taj. Who is Rubina Taj? Who is Rubina Taj? Jabin Taj antiದೆ. Notice that Annexure M is to Rubina Taj. Who is she? Petitioner Jabin Taj ಇದೆ.
ಅವ್ರು ಬರ್ತಾರೆ ನಾವು ಬರ್ಬಿಡೋದು ಸರ್ ಜಬೀನಾ ತಾಜ್ ಅಂತ ಹೇಳಿದ್ರು.
ನಿಮ್ ಪ್ರಕಾರ Jabin Taj and Rubin Taj are the same.
ಹೌದು ಜಬೀನಾ.
ಮತ್ತೆ ನೋಟಿಸ್ ಆಗಿದೆ ಅಲ್ಲ.
Address they have mentioned wrong. My address is the BTM level.
What is subject property?
It's a house.
What is the address of the subject property?
My address is number 15/1 5th Main Road, Bannerghatta, Maruti Incorporated, layout, Virappanapalli, that is.
ಅದೇ ಇದೆ.
But she was not residing in that address. She was only construction.
Find out whether it's been served. Hmm. Annexure H. This was also filed. ಒಂದೊಂದು ಜಾಗದಲ್ಲಿ ಒಂದೊಂದು ಹೆಸರು ಬರೀತಿರಲ್ಲ ನೀವು. You give a spelling differently every time. Here you are given ZABINA. JABEN. RABINA. You are giving different names to yourself. Can't be like that. Your name, your spelling has to be correct by you.
I have produced the other card.
Where's the Aadhaar card? Please be careful with your client's name.
In this petition, Retina.
Earlier, ನೀವೇ ಫೈಲ್ ಮಾಡಿದ್ರು.
ಹೌದು. Now, my lord, they will demolish my.
Have you filed an application at 240?
Yes, my lord, I will file my.
When did you
An
file?
except came on. Page number 52. 52 and 54. Find it.
ನೀವು ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್ ತಗೊಂಡಿರ್ಲಿಲ್ವಾ?
My lord, what happened, my lord? My husband died during 2020, COVID early that time. He was taking care of everything. And my son, my lord, is deaf and dumb. Therefore, my lord,
ಇಲ್ಲ ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್ ತಗೊಂಡಿಲ್ವಾ? ತಗೊಂಡಿಲ್ವೋ?
they are misplaced.
ನಿಮ್ಮ ಹತ್ರ ಇಲ್ವಾ ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್? Your records doesn't indicate. But he says they have one. If you have to say that there is no plan sanction, you have to verify your records. So if there is a plan sanction, then there is a question of violation. If there is no plan sanction, then it's illegal. If it is illegal, 248 will come in. They have filed an application at 248. What have you done with that? Demolition ಹೆಂಗ್ ಹೋಗ್ತೀರಾ? When once 248 is filed. Pawan Kumar accepts notice for respond number 1 to 4. 5 arrow.
5 the person who has lodged complaint.
Issue emergent notice to respond number 5 written by 11. The operation execution of the order passed under section 248(3) dated 15/3/2023 at annexure M is stayed till next date of hearing. Counsel for the respondent number 1 to 4 is directed to seek for instructions and make a submission as regards the status of the application submitted by the petitioner under subsection 8 of section 240 of the Act of the BBMP Act. As also whether the respondent number 1 to 4 has issued a plan sanction or not. Process fee and copies to be furnished by end of day tomorrow, failing which the interim order will stand automatically vacated. Accepting the reasons stated in support of IA 1 of 23, the production of typed copies of annexure A, B, C, E, and N is dispensed with. 11th.
Number 44, 45 as well. Finally, number 46.
Petitioner.
One ನಿಮಿಷ Mr. LBRES and GMRES ಇದೆ. GMO ಇದೆ ಇದರಲ್ಲಿ. VK Manjunath, Mohan Bhatt. R1 Karnataka land grabbing prohibition ಯಾರಿದೆ? Who is R1 in 46.1? SCGP accepts notice for respond number 1, 46.1. 46.2 alone, SCGP accepts notice for respond number 1. 46.3 ಕೊಡಿ. Malli Patil. Mr. Malli Patil, now he is in person. ಇಷ್ಟು ದಿನ ಬರೀ VCL ನೋಡ್ತಾ ಇದ್ವಿ. What is this? SCGP accepts notice for respond number 1. BS Prabhakar Garo. Sir, ಇದು 8704. ಇದು ಕೊಡಿ 10989. 10989. One ನಿಮಿಷ. 46.3 learned SCGP accepts notice for respond number 1. Prabhakar Gyara ಪೇರ್ ಹಾಕ್ತೀರಾ? Two in this one. MT Jaganmohan has entered appearance. MT Jaganmohan, who has entered appearance for respond number 2 in WP 8704 of 2017, is directed to accept notice for respond number 2 in the present matter. Shri BK Manjunath accepts notice for respond number 3. KM Alaswamy, KM Kumaraswamy, KC Purushottama. Shri SC Shivramu accepts notice for respond number 4 to 6. 4 to 6. Registry is directed to print his name as such. So adu mugitu. IA 1 of 18. What is 1 of 18? ಅಲ್ಲಿದೆಯಾ? ಹರ್ಡ್ ಆಗಕ್ ಮುಂಚೆ ಇದೆಲ್ಲ ಸ್ವಲ್ಪ ಕ್ಲೀನಿಂಗ್ ವರ್ಕ್ ಇರುತ್ತೆ. ಹಂಗೆ ಇದ್ಬಿಟ್ರೆ ಮತ್ತೆ ಯಾರು ಫೈಲ್ ಮಾಡಿರೋದು? R2 is filed in Nida. Appearance ಆಗಿಲ್ಲ ಅವರು. What is, Mr. Malli Patil, what is 1 of 18? ಯಾರು ಅಡ್ವೊಕೇಟ್ ಯಾರು? ಹೆಸರು ಯಾಕೆ ಬಂದಿಲ್ಲ? ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ನಿಮ್ ಕಾಪಿ ಬಂದಿದ್ಯಾ Mr. Malli Patil? IA 1 of 18 ಕಾಪಿ ಬಂದಿದ್ಯಾ? ಫೈಲೇ ತಂದಿಲ್ಲ. Statement of objection filed by R3. Copy ಬಂದಿದೆಯಾ ಇಲ್ಲ? 46 points. You have Mr. MT Jaganmohan's number? You have Mr. Jaganmohan's number? Don't have. Number ಕೊಡಿ ಅವರು. ಇದಕ್ಕೆ ನಂಬರ್ ಕೊಡ್ತಾ ಇದೀವಿ ಫೈಲಿಂದ. ಬರ್ಕೊಳ್ಳಿ. ಒಂದು ಫೋಟೋಗ್ರಾಫ್ ತಗೊಳ್ಳಿ. He has filed IA, he has filed objection. You don't want to refer to it? Or at the east court. All the also submit that neither IA 1 of 2018 nor the statement of objection filed by respondent number 3 have been served on them. Shri M.T. Jagan Mohan is directed to furnish copies to all the councils appearing in the matter. ಯಾವಾಗ ರೆಡಿ ಆಗ್ತೀರಾ?
Next week,
Relist on 10th.
Tuesday one day later.
VC ತಾನೆ.
Serial number 47 dismissed. Legal matter, serial number 48. Okay, what we have collected one.
It's not so many years there, not only the my time, my speech, but also public plan. Good, according to respondents only, we have certified like about out of 500. They are all going to suffer because lack of providing the document. They can't avail loans, they can't construct, they can't.
What is this matter about? We'll clear the matter. Please argue. You are appearing for the petitioner in one of Mr. Sadashivaya. Mr. Gangadharappa, you are appearing in all these matters. Amicus Curiae Venkatesh Arbatti is amicus. Okay.
Very modern scientific plan. For us having genuine documents.
We will dispose the matter, madam. 2012 matter. We are ready to hear you on merits. Please argue on merits. Mr. Shivraj Patil, Mr. Sadashivaya. Sadashivaya. So ನೀವು ಮೆನ್ಷನ್ ಮಾಡಿದ್ರ? ಓಕೆ, ಅದು ಬೇರೆ ಎಲ್ಲರಿಗೂ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರ ಅಂತ ಇದೆ. ನೀವು ರೆಡಿನಾ? ನೀವು ರೆಡಿ? ಫೈನಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ರೆಡಿನಾ ಮೇಡಮ್? ನೀವು ಫೈನಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್. ಮತ್ತೆ ಗಂಗಾಧರಪ್ಪ ನೀವು? ರಿಪೋರ್ಟ್ಸ್. Is there anything coming in the way of the matter being taken up for final hearing? ನೀವು ರೆಡಿ ಇದೀರಾ? ಅಲ್ಲಿ ಏನೋ ರಿಪೋರ್ಟ್ಸ್ ಅಂದ್ರು, ಅದೇನೋ ಬರ್ಬೇಕಾ? We can take it up. So there is nothing which will come in the, ನಾವು ಫೈಲ್ ಅಂತೂ ಓಪನ್ ಮಾಡಿಲ್ಲ, ಏನೋ ಅಂತ ಗೊತ್ತಿಲ್ಲ. So if there is nothing in the way which comes for it to be taken up, we will fix it. ಇವರು ಅರಬಟ್ಟಿ ಅವರು ಅಮೈಕಸ್ ಅಪಾಯಿಂಟ್ ಆಗಿದ್ದಾರೆ ಇದರಲ್ಲಿ. ವೆಂಕಟೇಶ್ ಅರಬತ್ತಿ ಇಸ್ ಬಿನ್ ಅಪಾಯಿಂಟೆಡ್ as amicus. ಅವನು ಕರೀರಿ. All the councils seek for and are granted 10 days time to get ready. ಎಲ್ಲದಕ್ಕೂ ಡೇಟ್. ಡೇಟ್ ಬೇಡ ಅಂದ್ರೂ ಡೇಟ್. ನಿನ್ನೆ ಯಾರೋ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಬೇಡಿ, ಅದಕ್ಕೂ ಕೊಡಿ. All the councils seek for and are granted 10 days time to get ready and address their arguments in the matter. We list on 21st August.
49. Is being Varaya.
Inquiry is complete. $25? Yes. Respond.
Respondent number 4 is filed, among some documents that have not served me.
Respond number 4 is filed.
Yes.
Mr. Sagar, you have filed something which you are not given the other.
My lords, in fact, my lords, there was a direction by your lordships, my lords, to the government advocate to procure those documents and to produce it before your lordships, my lords. 17/4/2023, my lords. It was an order of your lordships, my lord.
SCGP was directed to file the report.
Yes, my lords.
ಯಾವಾಗ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ? ನೀವು full report produce ಮಾಡ್ತೀರಿ. You are directed to send to the petitioner and respond 4 and 5, not in compliance with order date 33. You will direct file the entire report before this court. This is the entire report, either. ಇದು ಬಿಟ್ಟು ಇನ್ನೇನಿಲ್ಲ.
Very report is submitted by court respondent instead of the government.
That we'll deal with, depending on the nature of it, we'll deal with later. Hacking ಮಾಡ್ತಿದೆ. Your inquiry report, a private party is filing. So now you have received this copy? ಇವರು ಕಳ್ಸಿಲ್ವಾ ನಿಮ್ಗೆ? ಕೊಡಿ ಒಂದು ಕಾಪಿ ಕೊಡಿ. SCGP, the counsel for respond number 5 submit that she has not received the copy of the inquiry report, where SCGP undertakes to furnish the same given 4 days time. Mr. Vivekananda, you have received it? TP Vivekananda, counsel for respond number 3 confirms receipt of the inquiry report. What about petitioner?
Petitioner, my lords, I have served a copy on him, my lords.
Deceased petitioner. Petitioner is deceased. Again, deceased petitioner.
It's a body, my lords.
The president is deceased. Is anybody else represented? It won't abate, but somebody else will have to come on record. Where is Supreme? Relist on. So do you want to file any objections to the inquiry report? Then SCGP is also directed to furnish copy of the inquiry report to the petitioner. The, as I said, copies to be furnished on or before 9th August. In the event of the petitioner or respond number 5 intending to file any objections to the said inquiry report, objections to be filed on or before 24th, relist on 29th. 24th, after serving a copy thereof on the other councils. I will matte other service agilla ankoda.
Serial number 50, adjourned, 51. Adjournment for this because senior isn't available today. If you can leave timing, we'll have it in the next week. I'll fix a day for the.
Mr. Prabhakar,
Yes, my lord, I am very well.
you are ready?
My lord, maybe taken up on next week, my lord.
At the request of counsel for the petitioner and respond number 2, relist on 10th August.
Please, my lord, please.
No problem.
52. Pass over.
54, 45 forward.
Kaustubh. Ready? ಅಲ್ಲ ನೀವು ರೆಡಿನಾ? ರೆಡಿನಾ? ಇದು ಮೈಕ್ ಇಲ್ಲ ನಮ್ಗೆ. ನೀವು ರೆಡಿ ಅಂದ್ರೆ ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀವಿ. None appears for the petitioner at the request of counsel for respond number 3, released on 10th. 12th till 11th, yes, 11th. You are appearing to 2B and 3. 2A and C is held sufficient. Who is junior law office? R1. R1 is BBMP na? Shri Pawan Kumar accepts notice for respond number 1. Papers idya? Counsel for the petitioner serve. Registry that release the name of junior law office is that appearing for respond number 1 and instead print the name of Shri Pawan Kumar. Counsel for the petitioner is direct furnish one more copy of the petition along with annexes. In one copy on Shri Pawan Kumar. New objection hakidira? Counsel for respond number 2B and 3 is directed to furnish a copy of the objections and any other documents filed by them to Shri Pawan Kumar. Shri Pawan Kumar copies. Ibro ಕೊಟ್ಬಿಟ್ರಾ? ಹಾಗೆ ಒಂದು ಪೆಸ ಹೊಡೆದಾಯ್ತು. ನಿಮ್ ಕಾಪೀಸ್ ಎಲ್ಲ ಬಂತೇನ್ರಿ? ರಿಟ್ ಪಿಟಿಷನ್ ಕಾಪಿ ಬಂತು. ರಿಟ್ ಪಿಟಿಷನ್ ಕೊಟ್ಟು ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಕೊಡಿ ಕೊಟ್ಬಿಡಿ. Another set of the petition as also the objections are now furnished to Shri Pawan Kumar, who seeks for and is granted 2 weeks time to go through the same and get ready to make his submission. Released on 21st August. 22nd August. Yes, Mahisha.
Thank you.
Today. 6 served, 8 served, 7, 9 served. Okay, so new how will you file your vakalatama? Yarge. Again, so want to submit that you will be filing vakalatama for respond number 3 and 4. If such vakalatama is filed, registry is direct print his name as that appearing for 3 and 4 and delete the name of Shri A.S. Mahisha as that appearing for 3 and 4. When will you get ready? All the counsels seek for and are granted 10 days time to get ready and address their arguments in the matter. Released on 21st, it made clear that no further adjournment to be granted. Till 2017, or yaudidyo nimdu get ready.
My lord, sir, I request a week's time, my lord, a week time.
Why, Mr. Igde?
Was a little unwell, my lords. Next week.
At the request of counsel for the wakalat not filed until the R3 arrow.
Well, it's R3 is Nelamangala Town Municipal Corporate Council.
Is this
Nelamangala
counselor
Town.
on the panel? Is he on the panel? Panel. Idhar or panel idhara? Vakalat hakilla. Ye Nagarajappa. A. Nagarajappa is directed to accept notice for respond number 3. Registry direct print his name as such and delete the name of Sri S.R. Kamalacharan as that applying for respond number 3. Counsel for the petitioner to serve a copy of the petition along with annexures on Sri A. Nagarajappa. Released on 30th August.
There are 59 adjourned, 60.
Who will appear now? Sri Pawan Kumar. Bandhira. Sri H. Devendrappa has entered appearance for R1 and R2. Registry direct delete name of Sri Dr. R. Ramchandran as that appearing for R1 and R2. The counsel for the petitioner seeks for and is granted 1 week's time finally to get ready to address arguments. Released on 22nd August, it was made clear that no further adjournment would be granted. Interim order earlier granted is extended. Madam, if you don't address arguments on that day, it will get dismissed. Yentiganandi Gram Panchayat. The M.A. Devraj was entered appearance for R2 and 3, excess notice for respond number 1 also. Registry direct print his name as such. Ready?
Tax matter that we are going to negotiate with the respondent.
Tax matter negotiating agreement.
Except
Negotiating matter, whether it's liable to be paid, I say authority.
liability to be in excess.
Stay with the law.
Itself is
Take action. Stay ilwal. Clarify madana. Only for arguments. Five lakhs was not paid.
We have paid excess amount. That is the reason.
If there is a direction of this court, you'll have to comply with it. Normally, whatever your accounts have to be settled. If you are not complied with it, then the interim order will not be there. Interim order ಏನು ಇಲ್ಲ ಇಲ್ಲಿ.
Financially, court intention.
The M.S. Devraj, counsel for respond number 2 and 3 for the respondents would submit that the order dated 18/12/2018 has not been complied. If the same has not been complied, the interim order would automatically lapse. Counsel for the petitioner seeks for and is granted
To verify whether
10 days time to get ready and address arguments. Released on 22nd, it is made clear that no further adjournment will be granted. If arguments are not granted,
also submit with regard to deposit as per interim.
5 ವರ್ಷ ಆಯ್ತಲ್ಲ. If you want to negotiate, close it. Otherwise, argue the matter.
Okay.
ಏನಿದ್ರೂ ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್ ಆಗ್ಬೇಕಲ್ಲ. ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಮೇಲೆ ನಡೆಯಕ್ಕಾಗಲ್ಲ. Get ready and address argument. ಅದೇ ಮ್ಯಾಟರ್ ಅಲ್ಲ. You should not keep this matter. ಹೊರಗಡೆ ಎಲ್ಲ ಪಾಪ ಏನಾಗ್ತಾ ಇದೆ ಗೊತ್ತಿಲ್ಲ, ಎಲ್ಲ ಬ್ಲೇಮ್ ದ ಜುಡಿಷಿಯರಿ ಕೊಟ್ಟಿಲ್ಲ. ಪಾರ್ಟೀಸ್ ಬ್ಲೇಮ್ ಮಾಡಲ್ಲ ಯಾರು. Nobody knows it is the client who is taking the adjournment. It's not. Should not keep this matter pending. Court is ready to take it up. Get ready.
Abhinava,
Abhinav? Password?
serial number 63. Vice Chairman Shetty.
Yes.
Like this matter had come up before your lordship on the previous occasion. There is my lord, the amenities.
Who is appearing for response? Mr. Sanjeev?
Yes, Sanjeev.
My lord, I am appearing for the petitioner in this matter, my lord.
ನಿಮ್ದು ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್
My request
Sanjeev?
next week, my lord, I have some infection, my lord, that is the reason.
ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
My request is next week, my lord.
You want adjournment? ಯಾಕೆ?
My lord, may I request the matter to be taken up next week, my lord? I have an infection. Please, my lord.
62.
I have an infection, my lord. That is the reason.
Your case. At the request of counsel for the petitioner, released on 22nd, it is made clear that no further adjournment would be granted. If arguments are not advanced, dismissal.
Please.
Mr. Sanjeev, you ready na?
In fact, my lord, what had happened is, kindly recollect.
Or bandmel, pass over. Please inform Mr. Sanjeev also to come.
Can take up on Monday and inform him.
ಇಲ್ಲೇ ಪಕ್ಕದಲ್ಲಿ ಇರ್ತಾರೆ ಕರೆದು ಬಿಡ್ರಿ ರೆಡಿ ಇರೋದು ತಗೊಂಡ್ಬೇಕು.
There is a direction from the tribunal, to implement the order dated. Pass the order.
Yes. Kiran Kumar. You have to comply with the order dated 28/3. Learned additional government advocate and respond number 4. Respond number 4, Gyaro. Mr. Kumparna. Seeks bond is granted a week's time to obtain instruction as regards to the directions, if any, issued by the state in terms of the order passed by the NGT Principal Bench New Delhi in OA number 134 of 2015 dated 1/12/21. Any instructions put together? (28/3) order. Again, 10/4 you took time. 16/6 to list agilla. Date number that list agilla.
We better sustain this. Around 600 pages. Daily order.
And council, SCGP and council for petition number, respond number 4, seeks bond are granted 1 week's time finally to comply with the order dated 28/3/2023. Released on 21st.
Number 65 order. 66. Yeah, Ramesh.
CMC Mysore.
I'm the respondent 3 in this case, my lord. Statement of objection has to be filed.
Has to be filed. Who is for CMC Mysore?
CMC care.
KR Nagara. Yaru. Mr. BJ Somiyaji is directed to accept notice for respond number 4. Counsel for the petitioner to serve copy of the petition along with annexes on Sri BK Somiyaji, BJ Somiyaji. Sri S.V. Mukkarnappa seeks for and is granted 2 weeks time to file a statement of objection. Objections, if any, to be filed.
Sharp point is involved.
2 weeks wait one either.
For the last more than 6 months, they are taken. Next week.
22 matter.
Construction materials for.
Objections, if any, to be filed by 18th August after serving a copy thereof on the counsel for the petitioner. Relist on 23rd August, it's made clear that no further adjournment would be granted.
Yes.
If objections are not filed by 18th, it will be taken as not filed.
Much.
ನಿಮ್ಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿಲ್ವಾ? ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರು. ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರು. 67 ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. When the matter was not called, Sri Ganapati Bhatt, learned counsel for the petitioner, inquired about the same and has submitted that he was not informed about the rest. About respond number 2 and 3 seeking for an adjournment. ಯಾವ date ಇದೆ? 29/8. ಅದಕ್ಕೆ ಅವ್ರು ಕೇಳಿದ್ರು ಟೈಮ್ ನಿಮ್ಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀವಿ ಅಂತ. ನಿಮ್ಗೂ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರು. That is why we insist that they have to inform. ನೀವು ಯಾವ್ದೋ ಕೋರ್ಟ್ ಬಿಟ್ಟು ಓಡ್ ಬರೋದೇನಕ್ಕೆ ಅದು? 2 and 3 ತಗೊಂಡಿದ್ದಾರೆ ಟೈಮ್. ಅವ್ರು ನಿಮ್ಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ ಹೇಳ್ತೀವಿ.
Only for sitting.
Mandamus objection.
Where I is an actual property matter. Initially, it is the property in the name of Will be name of Will Diana. Later, it is transferred to his son MD Kumar. MD Kumar is executed a partition deed in the name of his children. So they want to mutate their records in their name. For that, I have given a representation to the
family as well.
Family as munche avara ittu adanu transfer ಮಾಡ್ಕೊಡೋದು ಅಷ್ಟೇ.
ನಿಮಿಷ ಅವ್ರು ಹೇಳದ್ ನೀವ್ ಹೇಳಿದ್ ಕೇಳಿದ್ರೆ ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ? ವಿಚ್ ಡಾಕ್ಯುಮೆಂಟ್ have not given? ಏನ್ ಓದಿ ರಾಮತಾನ ಮೂಲ ದಾಖಲೆ ಸಿಗಲ್ಲ. ಟ್ಯಾಕ್ಸ್ ಪೇಡ್ ಕೊಟ್ಟಿಲ್ವಾ? ಕೋರ್ಟಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಅಪ್ಲೋಡ್ ಮಾಡಿ ಅಷ್ಟೇ. ಲೇಔಟ್ ರೆವಿನ್ಯೂ
ಮುಂಚೆ ನಮಗೆಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ ಸ್ಕ್ರೂಟಿನಿ ಮಾಡಿ ಟ್ರಾನ್ಸ್ಫರ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಇನ್ ಮೈ ನೇಮ್ ಅಲ್ಲಿ ಫಾದರ್ ಆಫ್ ದಿ ಪಿಟಿಷನರ್.
ಇವಾಗ ಲೇಔಟ್ ಆಗಿದೆಯಾ? ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್ ಆಗಿದೆಯಾ? ಲೇಔಟ್ ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್ ಆಗಿದೆಯಾ? ಲೇಔಟ್ ಇಲ್ಲ ತಾನೆ? ನಾಟ್ ಅಪ್ಲಿಕಬಲ್ ಅಂತ ಬರೀಬೇಕು ಅಷ್ಟೇ ನೀವು.
ಲೈಸೆನ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಅಷ್ಟೇ ರೀಮೇಕ್
ಆಲ್ ದೀಸ್ ಆರ್ ನೌ ಆಟೋಮೇಟೆಡ್. ನೀವು ಹೋಗ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಏನೇನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಕೇಳಿದ್ರೆ ಅದು ಫೈಲ್ ಮಾಡಬೇಕು. ಅಪ್ಲಿಕಬಿಲಿಟಿನೋ ನಾಟ್ ಅಪ್ಲಿಕಬಿಲಿಟಿನೋ ಹೇಳ್ಬೇಕು ಅಷ್ಟೇ. ದಿಸ್ ಕ್ವೆಶ್ಚನ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ ನಾಟ್ ಸಬ್ಮಿಟೆಡ್ ಬರಲ್ಲ ಇವಾಗ. ಎವ್ರಿಥಿಂಗ್ ಇಸ್ ಎನೇಬಲ್ಡ್. ಮನೇಲಿ ಕೂತ್ಕೊಂಡು ಅಪ್ಲೈ ಮಾಡ್ಬೋದು. ಈ
ಕೇಳಿದ್ರೆ ಅನೇಬಲ್ ಟು ಸೆಕ್ಯೂರ್ ದೋಸ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಮೂಲ ದಾಖಲಾತಿ ಕೇಳಿದ್ರೆ It's not
Very
available.
good, not available and not required.
Then they have acted upon my representation, then I will be put into trouble, man. But only because of that, the original record is not available. On that basis, they have reject my application.
ಆಮೇಲೆ ಫಸ್ಟ್ ಅಲ್ಲಿ ಏನೇನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಕೇಳಿದ್ರೆ ಕೊಡ್ಬೇಕು ನೀವು. ಕೊಡದೆ ನೀವು ಬೇಗ ಬಂದ್ಬಿಟ್ರೆ ಏನ್ ಮಾಡೋದು?
Initially, ನಾವೆಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ ಸರ್ ನಾನು. Based on that, the property was located in the name of my father.
ಅದೇ ಇಟ್ಕೊಳ್ಳಿ ಹಾಗಾದ್ರೆ ಇನ್ನೇನಕ್ ಬೇಕು ನಿಮ್ಗೆ? ಇವಾಗ ಬೇಕು ತಾನೆ? ಏನ್ ಗಿರೀಶ್? ಇದು ಯಾವ ಕೊಡ್ತೀರಾ? Again, they have to give it to you online or offline?
Online ಅಲ್ಲಿ ಕೊಡ್ತೀವಿ. ರಾಷ್ಟ್ರೀಯ ಡೈರೆಕ್ಟ್
I'll ಹೋಗ್ಬಿಟ್ಟು ಕೊಡಿ, because your portal must have got closed now for you. But next week, everything will be done. Learned Counsel for respond number 254 submit that there are a few documents which have not been furnished by the petitioner. And if the same were furnished, the application will be processed. Learned Counsel for the petitioner seeks for and is granted 10 days time to either upload the documents online or to furnish physical copies of those documents to respond number 224. To enable respond number 224 to upload it on the portal. Relist on 22nd, 29th to report further progress.
My lord, I'm appearing for petitioner, my lord.
Yes.
My lord, it is a petition for mandamus, my lordship. We have given representation for consideration.
Michael ಮಾತಾಡಿದ್ರೆ ಅವ್ರು ಕೇಳಲ್ಲ. What is your plan? Footpath. This is an order of 26/6. It's taken more than a month for you to even get instructions. No 2 weeks. Who is to give you instructions? Despite the order dated 26/6/2023, the Counsel for respond number 1 to 3 seeks for 2 more weeks to obtain instructions and make his submissions. The said request is not reasonable and as such is rejected. If the instructions are not received and submissions are not made by 10th August, respond number 3, respond number 2 na 3 na? Respond number 3 shall be personally present before this court. If you don't get instruction, we'll call them. 8/10.
Serial number 70, adjourned, 71. 11.
Jointer is ready.
You rejoined her, then madam will want to see that.
Master plan.
You should serve it beforehand.
No, morning they came, because that's a big one they have gone for.
See, whatever it is, each council is entitled to earlier.
Yes.
Yes.
Monday.
Monday, madam. The counsel for the petitioner submit that he will be filing a rejoinder during the course of the day after rejoined to the statement of objection during the course of the day after serving a copy thereof on the counsel for respond number 1 and 3. Counsel for respond number 1 and 3 seeks for and is granted 2 days time to go through the same and make a submission after obtaining instruction. Relist on 8th. 9th.
Interim order to be.
Interim order earlier granted is extended till next week.
72. Adinarayappa.
Consider.
Instructions, Pawan? Hello, Pawan. Pawan. 72. Mallikarjun? Wakalat ಹಾಕಿಲ್ಲ ಅವರು. Password. How long does it take to get wakalat? Wakalat ನಿಮಗೆ ಬರಕ್ಕೆ ಎಷ್ಟು ದಿನ ತಗೊಳುತ್ತೆ? Four to 5 days. Now that e-filing 3 has been commenced, cannot the Wakalatnama be filed online by BBMP? Training for Waka. Do the BBMP officers and the councils require training? We'll arrange for training. Really? On some Saturday or so. Both the officers, how they can file from their office and how you can file from your office, we'll do that. So this kind of things will be avoided. Password.
Lateral color.
Yes.
Let's save the copy of the respondents.
Prasad Egdev is here. Pass over, let us get. We'll pass over. Let us get them there.
74. Vijay Shetty.
Malad, kindly pass over, Malad, for 2:30, Malad. I'll appear before the court, Malad.
Pass over.
Please.
Twenty-one at the request of counsel for the petition released on 9/10. 10th ಇದೆಯಲ್ಲಪ್ಪ ಒಂದು week full ಇದೆ. 10th. Yes.
Serial number 52. Sayeda Shehla. 54. Sudhika Ishwarwar.
Pass over.
63. Vice Chair.
ಆರ್ ಮಂಜುನಾಥ್ ಅವ್ರು ಬೇಕಾ?
Local villages, they are ready to give them the action.
They are ready to pay.
Yes.
Their statement has been recorded. ಯಾವಾಗ ಮಾಡ್ತಾರೆ?
They pay, they will already.
ಯಾವಾಗ payment?
Make a demand. Memo is filed on 6/4.
ಇದು ಹಿಂಗೆ ಪಿಂಗ್ ಪಾಂಗ್ ಬಾಲ್ ಆಗ್ತಾ ಇರೋದು.
May I request your lordship? 6/4/2023, I have filed one memo along with the documents indicating that, my lord, what are the charges that are required to be paid in respect of this 110 villages that I have placed before your lordship. In terms of that document, my lord, we are ready to.
What is the amount they are required?
Since they have not made the application, but demand has to be. They are approving.
Correct. Once you file the application, they will calculate and then raise the demand.
Application in the sense, my lord, individually it cannot be filed. It comes under 110 villages. So for the
10
entire
villages,
year, it has to be
it is
paid.
not a public interest litigation. It is only insofar as you are concerned.
So in respect of our association is concerned.
Insofar as the supply of water and sanitation to your layout.
In terms of 110 villages, the scheme. under the scheme.
ಹಿಂಗಾಗತ್ತಪ್ಪ 110 villages.
110 villages, that is what, my lord, document I have placed for your lordship.
If that is the way that you want it to be done, this will never get done. And until all the 110 villages are done, you will be the last person standing in queue. If you want to file an application, you are free to do. If you are not going to file an application, we'll dismiss this petition. If you are not willing to do, then how will they give you a supply? When will you make an application?
Next week we will make an application.
I mean, leave it.
10 days they will process it. Whatever the present rates for that, they
So we will keep it after 3 weeks.
please, in the meantime, we will find out.
The council for response number 3, 4, and 8 submit that if an application is filed for water and sanitation connection by the petitioner, the same would be processed and a demand raised as regards the beneficiary capital contribution to be paid by the petitioner. Learned counsel for the petitioner submit that given 10 days time, an application will be filed. At any rate before 18th August. If needful is done, if the said application is filed, respondent number 3, 4, and 8 to process the said application, raise a demand within 10 days thereafter. Relist on 5th September. Bharatan, you do put it, we'll fix the time.
What was Supreme Court case pending for
I get some water.
72. Radhinarayana.
ಅದು ಅವ್ರು ಬರ್ಬೇಕಲ್ಲ ಇಲ್ಲ ಯಾರು who is to appear? Shri Mallikarjun? So and so. Shri Pawan Kumar submit that Shri so and so would be entering appearance for respondent. Hence register his direct print his name and delete the name of Shri Pawan Kumar as that appearing for respondent. Relist on 8th August.
73. Letter Balan.
Yes, madam.
In fact, second, you must have directed the department for to take notice one of the matters of the respondent 1, 2, and 4. But in the order uploaded into the file, oversight it has given 1, 2, 3, and 4. So 3 is the private party where I have to pay the process fee. Unless there is an order, office is not taking the
List Monday. File Monday.
there is a date, like inspection of 9 July. And that is the reason I am.
ಮಧ್ಯಾಹ್ನ ತರಿಸಿ ಇವ್ರಿಗೆ ಬೇಗ ಬರುತ್ತೆ
ಕೊಟ್ಟು ರಿಸೀವ್ ಮಾಡಿಸಿ ಬರ್ಬೇಕು 2 ಬ್ರಾಂಚ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಒಂದು 55 ಬರ್ಬಿಟ್ಟಿದೆ ರಿಸೀವ್ ಮಾಡೋದಕ್ಕೆ ಒಂದು ಅರ್ಧ ಗಂಟೆ ಬೇಕು ಅದಕ್ಕೆ ನಿಮ್ಗೆ ಬರ್ಬೇಕು ಬೇಗ ಅಂತ ಹೇಳಿದ್ರೆ ಈಗ ಮಧ್ಯಾಹ್ನ ತರ್ಸಕ್ಕೆ ಹೇಳ್ತಾರೆ ಇದು ಮೆಮೋ ಫಾರ್ ಪೋಸ್ಟಿಂಗ್ ಇರ್ತಾರೆ ಮಧ್ಯಾಹ್ನ ತರ್ಸಿ ಅಂತಾರೆ ಅದಕ್ಕೆ ನಾವು ಬರೆಯೋದಕ್ಕೆ ಮಾಡ್ತಾರೆ ಸ್ವಲ್ಪ ನೀವು ಅರೇಂಜ್ ಮಾಡಿ ಅವ್ರ ಹುಡುಗ ಇಲ್ಲ ಅರ್ಧ ಗಂಟೆ ಬರಲ್ಲ ಇನ್ನು ಈಗ ಅಸಲು 2:30 ಆಗಿದೆ ಅವರು ಫೈಲ್ ಹೇಳಕ್ ಬೇಜಾರು ಯಾಕಂದ್ರೆ ಅರ್ಜೆಂಟ್ ಮಂಟೆಗೆ ಅಂತಂದ್ರೆ ಪರವಾಗಿಲ್ಲ. ಯಾಕೆಂತಂದ್ರೆ ಏನ್ ಇಷ್ಟಿತ್ತು ಅದು ಆಲ್ಮೋಸ್ಟ್ ಕಂಪ್ಲೀಟ್ ಆಗುತ್ತೆ ಅದಕ್ಕೆ 2:45 ಹೋಗ್ಬೇಕಾದ್ರೂ ಪರವಾಗಿಲ್ಲ ಇಂಜಿನ್ ಮೆನ್ಷನ್ ಹಾಕಿದ್ದೆ ಮುಂದೆ ಕಲ್ಪಿದ್ದಾರೆ ಹೇಳ್ತೀನಿ ಅದನ್ನು ಹೇಳ್ತೀನಿ. ನೋಡೋಣ ಮೇಡಮ್. ಓಕೆ ಓಕೆ ಓಕೆ. ರೆಡ್ಡಿ ಫಸ್ಟ್ ಫೈಲ್ ಮಾಡಿದಾಗ ಟೈಮ್ ಶೇರಿಂಗ್ 2 ಜನ ಇತ್ತು. ಇವ್ರೇನೋ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡಿದ್ರು ಅದಕ್ಕೆ ಇವ್ರನ್ನ ತೆಗೆದು ಯಾಕಂದ್ರೆ ಇದು ಈ ಸಂಸ್ಥೆನೇ ಇಲ್ಲ ಅದಕ್ಕೆ ಅವರು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡಿರ್ತಾರೆ ಡಿಲೀಟ್ ಮಾಡಿ ಹೊಸದ ಇದು ಅದಕ್ಕೆ ಇಲ್ಲಿ ನೀವು ಮಾಡಿರೋ ರೆಫರೆನ್ಸ್ ಏನ್ ಮಾಡುತ್ತೆ ಲಾಸ್ಟ್ ಮಾಡಿಸ್ತಾರೆ ಅಸಹ್ಯ ಅಂತ ಇವಾಗ ನಾನು ಇದನ್ನೇ ಮಾತಾಡ್ತೀನಿ ಪಾರ್ಟಿಸಿಪೆಂಟ್ ವಾಟರ್ಸ್ ಎಲ್ಲ ಸರಿ ಹೋಗುತ್ತೆ ರೈಸ್ ಮಾಡ್ತಾರೆ ಎಲ್ಲ ಕರೆಕ್ಟ್ ಮಾಡ್ತಾರೆ ಆ ಸಂಸ್ಥೆ ಅನ್ನೋದೇ ಇಲ್ಲ ನಾವೇ ಊಟ ಮಾಡೋಣ ಚೇಂಜ್
Court officer?
ಸರ್ ಹೇಳಿ ನಾಯಕ್ ಸರ್.
ಮೇಡಮ್ ಗುಲ್ಬರ್ಗಾ ಬೆಂಚಿಗೆ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ರಿಲೈ ಮಾಡ್ತಾ ಇದ್ದೀನಿ 1995 2S page 1.
ಇನ್ನೊಂದ್ಸತಿ ಹೇಳಿ 1995
Volume 2 page 1. SEC page 1.
ಓಕೆ ಸರ್. ಓಕೆ,
Thank you, madam.
ತರಿಸ್ತೀನಿ.
So before pronouncement of judgment, my lord, I would like to submit one thing, my lord.
Yes, Mr.
Yeah, my lord, in a writ petition, other day, the 3 writ petitions were connected with this batch, my lord.
Yes.
Another writ petition 20015 of 2022 was turned infructuous by this.
My lords, the court is not audible.
Can you hear us, Mr. Bharat?
Yes, my lord, I am hearing. My lords, one writ petition was turned infructuous by this court, but
Yes.
since that in that writ petition, my lord, a vacating stay had been filed by the defendant, and that had been turned rejected by after filing of my suit of partition, my lord, and that was carried in the MA also, my lord. And that was challenged in the writ petition 20015 of 2020. This was not brought to the notice of the court, my lord. And it was turned infructuous straight away. Lords,
Then you'll have to file a recall up. It was not pronounced in your presence.
yes, my lord, that's what, my lord, I have to, for that reason, I am submitting, my lord, that that was not brought to the notice, and even in fact, I had also not been gone through it. Subsequently, had gone through, my lord. MA was also filed, and vacating stay was filed after filing my suit, my lord, my suit of partition. And both the courts have answered negative to the plaintiff. I have to file recalling application to that effect, my lord, to that.
Then we can't pronounce orders in these matters.
Lordship,
That's what, my lord, I want to submit, my lord. That's what.
Lordship.
Yes,
May I be? In those 2 proceedings, Your Honor, MA 39 has been considered that since the appellate court has passed the order, they cannot interfere. That is the reason. They have not taken into consideration the points urged by us in that.
See, both of you are addressing this in vacuum without anything before us.
My lord, that's what, my lord. If the file is at least not
take a decision this way or that way.
No, my lord, what I submitting, my lord, I am not the decisions, my lord. If the petition of 20015 is tagged, and if my lord peruses that petition, my lord may.
That is already disposed of until you file an application.
My lord, that's what, my lord, I will file a recalling application, bringing to my lord's notice, my lord. That's what.
So when will you do that?
My lord, in next week I will file. My lord, the date may be fixed so that that matter can be we will heard, my lord, by this court, so that it will be appropriate.
Once you file recall, then we'll have to give you a date.
Yeah, that's what, my lord. I will file Monday itself, my lord, Monday or Tuesday itself.
Mr. Bharat.
Pardon?
That's
what, my lord. I am extremely. I feel apologies to the court and as well as, my lord.
What you are saying will have an impact on these matters. Is that
yes, my lord. Yes, definitely, my lord. Definitely.
Shri Deepak Bharat, before the orders are pronounced, Shri Deepak Bharat, Learned Counsel for the tenant, makes a submission that insofar as WP number, what is that number?
20015 of 2022,
which had been disposed by holding it infructuous. In respect of so you would be filing an application for recall to review, since he was unable to place certain orders passed in that matter for the consideration of this court. If that be so, then orders cannot be pronounced in these matters, since the present orders would depend on the outcome of that recall application.
Lordship, as far as 201240 of 23 is concerned,
yes,
it is not connected to anything.
Now we have made a common order. If that is the thing, then we'll have to split everything.
Please, please. Sir, one submission.
Let him file the application, let us consider it.
Please, please. A date may be given, sir. So
nothing
that,
will happen in another week, 10 days, Mr. Dharat. Let there be no.
No, not an issue, sir.
Shri Deepak Bharat submits that the application will be filed within a week from today. Release these matters for further hearing on 21st August at 2:30 p.m.
Oh, bless.
Please.
In the event of an application for recall being filed, the said application and writ petition number so and so to also be tagged along with the above.
Matter pertains to Sargu student, serial number 2, VK Nayak.
Next to appear for the.
Lord.
Was it parted?
Yes, ma'am.
Withdrew. Oh, yes. 13/7/23. 15/7. In 7/20. Ah, yes. Page 8, 6/2016. Mallikarjuna. Fifteen seventh. Page 3.
2 years of electrician trade. The practical training scheme and 1 year apprenticeship training 2 plus company for 3 years. Under apprenticeship act, equivalent to 3 years of full-term apprenticeship training. This seems to be some certificate, not the what. Enclosure is extract of apprenticeship act of 1961. But,
Issued by the Employment and Training.
this is what not produced. And it's in the annexure place, this page. This certificate seems to have been issued based on extract of not the rules, scheduled to the rule of 1992. Which indicates the next page, top of that group 4, electrical trade group, electrician, 3 years electrician, 3 years relate. This seems to be not the basis on which some certificate is issued. Last time I made a submission that we tried to verify the authenticity of this plot. The department plot does not authenticate plot that such a certificate has been issued. For the reason plot that the schedule does not find a place in the rules. I have taken
That you'll have to get us from the Directorate of Employment and Training as to whether they have issued this or not.
We try to verify with them. Also, not formally ask them to confirm.
For us, we have this certificate.
Some copy which is right of 2014. It's there, it's a number of
If you are saying that it's not correct and could not have been issued, you should get something from this department saying that we have not issued it.
we have already sought that.
If you're not able to do it, we'll have to go by this, that it is there. Otherwise, we'll have to go by this.
Can you see the schedule?
Technicalities of it, they'll file. If you're disputing this, you'll have to show how.
On the face of it. Because of the road, we have a schedule in the road. There is no such.
You can't do that. The certificate which is being by the concerned.
Group 4, I'm taking the liberty of marking not.
They do.
This is 92 rule.
Electrician is there, group.
Electrician is there. 2 years, then rebate fraud is 1 year. Clear. It does not match with the 92 rules at all. And the class is also different. And NCO code is also different.
Substituted by GSR 22/2/2016. A footnote ಇರೋದಲ್ಲಿ.
And what is it? You don't get it.
61 footnote ಇದೆ ಅದಕ್ಕೆ. There is footnote 61, end note. End note ಅಲ್ಲಿ it says substituted in 2017. So what was it before 2000? This is 2014.
2014 is the certificate.
So what was it in 2014?
I told not there is no change in this.
You can't go by what is told, Mr.
There is no change.
You'll have to produce the 2014 rules. You're giving us 2017 rules to say it's not so.
No change as far as this replacement.
There has to be a change. Otherwise, that end note would not have been there. Each item is separate end note here. And there is a separate end note for item number 1 at 61. And 61 says substituted by GSR 198E, dated 22/2/16. So what was it in this certificate is of the year 2014? And your list is of the year 2014.
This certificate is of 2014. No? Yes, the petition is also 2014.
Your contention on this basis, certificate could not have been issued, cannot be relied on, cannot be accepted. So this is 2016.
But we found out that group 4 did not have this entry brought in time. And that has also been brought, we are awaiting confirmation from the department.
So you want time andre time ಕೇಳಿ. You want to argue andre argument ಮಾಡಿ. ಎರಡರಲ್ಲಿ ಒಂದು ಮಾಡಿ. Don't say both.
Rely on this certificate brought, let them file an affidavit supporting that.
You are the one who is saying no, Mr. You have to say, because it's substituted. Please understand what we are trying to say. It's not inserted. Substituted under, there had to be something prior to that.
Yes, sir. We verified it.
So your contention of, if you have verified it, you should have seen 2014 rules. So you should have it to give it to us. You can't verify it otherwise.
Available online, not yet verified it, but
Produce it. And if you want to file an affidavit, you also file an affidavit. Learned senior counsel appearing for respond number 1 and 2. Strongly denies the veracity of the certificate produced at certificate and annexure produced at page 3 to 5 of the memo dated 12/7/2023. In that view of the matter, the counsel for the petitioner is direct file an affidavit swearing to the authenticity of the petitioner, swearing to the authenticity of the same. If respond number 1 and 2 were to dispute the said document, it is for respond number 1 and 2 to produce a document contrary thereto, since the rules are relating to 2014, along with an affidavit of respond 1 or 2. Relist on Released on 17th, 10th. Sorry, Friday and 11th. 11th, Ms. Naik, just file it earlier.
Please,
So, come here.
taken a plan here. Then planning is with regard to the first and second floor. The authorities are given as a notice of deviation. Thereafter, I have prepared an appeal, page 26, where the appeal is pending before the court. Even before the appeal could be filed, they have initiated proceedings for demolition.
Before the appeal was filed, and that is different.
Appeal is pending.
With the now you can say that appeal is filed, so grant me stay and the other better. Even before appeal was filed, they have initiated and they should give you time to file appeal and
Appeal is pending. And
when did you file the appeal?
we filed this appeal.
On 24/7. 24/7/23 you filed.
Yes.
When did
It's not
they,
been taken up.
when was the impugned order passed?
27/7.
It was filed before. That is for you to take care of. We'll watch this. We'll watch this 27/7 order. And you hear the appeal and pass an order. So that is what has to be done. We don't need to consider this. The chief commissioner will consider that, and whatever is the facts, he'll pass an order. If they are agreed, they'll come here. If they are happy, they will not come here. If Pawan Kumar accepts notice to respond number 1 to 3, the petitioner is before this court seeking for the following release. The contention of Shri V.B. Shivakumar, learned senior learned counsel appearing for the petitioner is that though an appeal had been filed by the petitioner under section 253 of the Brihat Bangalore Mahanagar Palike Act 2020 in appeal number 91 of 2023, without considering the said appeal, the impugned partial building demolition order dated 27/7/2023 has been issued. The perusal of the appeal, there is no dispute that an appeal has been filed on 24/7/2023 and is numbered as appeal number 91 of 2023. And as such, I am the considered opinion that without considering the said appeal, the demolition order could not have been issued. Since the appeal is pending, it is for respond number 1 to consider the same and pass necessary orders thereon. And in the event of the petitioner failing in the said appeal, necessary orders for demolition could be passed. Needless to say, it cannot be passed before such consideration. As such, I pass the following order. Writ petition is allowed, certiorari is issued. The partial building demolition order bearing number so and so dated 27/7/2023 at Annexure A is hereby quashed. The second respondent is directed to consider the appeal number 91 of 2023 filed by the petitioner strictly in accordance with law within a period of within a period of 60 days from the date of receipt of copy of this order. Needless to say, the respondent number 2 shall provide adequate opportunity of the petitioner to be heard in the matter before passing any orders.
My lords, I appear for the petitioner in this.
Yes.
My lords posed a question regarding maintainability of the petition here, since the challenge, one of the respondent is Hubli Dharwad Corporation.
Yes.
My lords, I could not lay hands on the judgment of Justice N. Kumar Division Bench order, wherein it is said that it is open for the petitioner to file
When will you place it, Mr. Babu?
My lords, a week's time began. For this reason, this order of Justice N. Kumar, my lords, is challenged before the Supreme Court. I have seen the judgment, my lords, but the issue is kept open. 2016 matter is amended back and the matter is reopened in the High Court. A week's time may be granted.
Also, there is a circular which has been issued by this court in the administrative jurisdiction, saying that it would have to be filed in Hubli, Dharwad and Kalburgi. It cannot be entertained here.
My lords, the 2013 circular of this High Court, wherein it when the benches were made permanent, it has said, but the judgment of Justice L. Narayan Swamy was post to that order. And now I find there are contrary views expressed by different high courts. So I may be given some time to actually see how exactly the issue is decided at present, my lord.
It is, please don't waste time. Go to Hubli and file it. We'll transfer it if you want.
A week's time may be granted, my lord. So
It's in the interest of your client that you go there. Don't waste time here. The request of the counsel for the petitioner released on 11th August.
much obliged.
Millards, one submission.
Yes, madam.
Millards, to respond number 2, Millards. 5 and 6 Millards, HTMC, kindly show the name of Mr. Gurudev Gachinmat in the name of IG
He
Gachinmat.
doesn't
Delete
practice
the
in
name.
this court. How ನೋಡ್ಕೊಂಡು ಹೋಗಕ್ಕಾಗಲ್ಲ ನಾವು. That is the problem. All the lawyers will be there. Authorities are there. Just because you come here, we cannot call everybody here. Understand, Mr. Babu?
I understand, my lords. I understand.
You are a petitioner also from Hubli. All the papers are there. If you have to call for some papers, it has to be in Hubli only.
My lords, may I satisfy for myself and in the larger interest regarding that issue, my lords. On 11th, I'll make my submissions, my lord.
Don't make an academic exercise something which will, it's for you to decide.
Much obliged.
52. None appears for the petitioner, though called Rice. Appraisal of the order sheet indicates that none has appeared for the petitioner. If none were to appear for the petitioner on the next date of hearing, petition will be liable to dismissed for non-prosecution released on 11th August. Yes.
Other Mandala, here is the total number 18.
Monday.
Monday, Tuesday, we kindly do one.
We'll avoid. Wednesday.
Yes.
At the request of counsel for the petitioner, released on 9th August. Madam, there is some submission. What you want to convey in court, the words that are to be used are different. It's not colloquial way of can be avoided. You're just enrolled, so get to know from your seniors.
73.
70. Hello, did you tell Mr. Prasad Hegde to come?
No, my lord, no prayer against me, my lord.
You not filed your wakalatnama, Mr. Hegde?
Yesterday afternoon they gave the copy. Yesterday afternoon they gave.
What about Mr. Abdullah? Who are you seeking? How they respond numbers 2 and 3?
Yes, and for the development authority, my lord, notice issued by the first respondent, city municipality.
Respond number 1.
Yes.
Number 1. Udupi Municipal Council.
Yes. Because next week, my lord, I will inform Abdullah, my lord.
Yes. Inform Mr. Abdullah.
Yes, yes, my lord.
Released on 11th. Interim order earlier granted. It extended till next date of hearing.
Well, please.
74.
Yes, you appear for respond number 2. 2 to 5, yes. B. Vijay Kumar for R4.
My name also, they have wrongly mentioned as it should be Vijay.
74.1. Registry has printed the name of Shri B. Vijay Kumar as that appearing for respond number 4. Registry is correct the same as Vijay Shetty B for respond number 4. The government is not a party in that. Which one should we take up first? Ready, madam? First year work ನೀವು ಶುರು ಮಾಡಿದ್ಮೇಲಲ್ಲ.
This matter, the police are coming and trying to meanwhile it is interim order, let them find the objection.
What is it that you are seeking?
The interim order, stay of the actual ABC. But there is an interim order passed by this honorable court in the connected matter, stay of the further proceedings. By violating that order, they have issued the work order. You will also may kindly see the interim order is at page number 64, at the annexure L. At the annexure, page number 121. 121.
So the proceedings are staged.
Stayed, in spite of this, this other petition in the other case, he has been given the work order. That too before 31st of that is 28. Not by specific order is there. I have filed the contempt petition also.
And counsel for respond number 2 to 5 seeks for a week's time to file a statement of objections. In view of the order passed by coordinate bench of this court in WP number 14513 of 2022 dated 1/8/2022, the operation of annexure A, B, and C to the present writ petition are stayed till the next date of hearing. Statement of objections, if any, to be filed on or before 18th August, released on 23rd August.
Sir, hearing bill number 75.
ಇನ್ನ ಇದೆಯಾ ಯಾವುದು ಫೈಲ್ ಬಂದಿಲ್ವಾ ಫೈಲ್ ಬಂದಾಗ $135. Ramashetti.
Page
130?
139.
130.
That is the 8th page 130.
Yes.
Start at the last paragraph. Whatever might be the quantity of timber and firewood cut by the defendant, it is urged that it come and not that of the plaintiff, and that therefore the defendant is not liable for damages to the plaintiff. This argument is founded on the character of the holding of what is known as Parnell and Philippine. In Appendix 3, the conditions given in the group revenue manual, Bana is described as forest land, granted for the service of the holding of wetland, to which it is allotted, to be held free of revenue by the cultivator for grazing and to supply leaf manure, firewood, and timber required for the agricultural and domestic purposes of the cultivator, so long as he continues in possession of wetland. Such bane may be attached to wetland held under Jamma tenure, Upi tenure, or Sadhu tenure. The lands held in Jamma or Upi tenure are not fully assessed and are not alienable, while land held under Sadhu tenure is alienable. Since the bane is granted only for the purpose of making limited use of the forest produce, and the holder has no right to cut and remove the timber out of the bane land or for purposes other than for the service of the main holding, it is urged that the timber is the property of the government. The Food Land and Revenue Regulation 1899 does not define any of the tenure mentioned above, and the definition referred to above is not strictly speaking a statutory definition. There is nothing in the above regulation to affect the character of any of the above tenure. We have therefore to see that the character of bane tenure is as understood by customary law and practice. In Bedin Brown's book on land systems in British India, it is stated as follows: the bane is destined to supply the one holder with grazing, timber, firewood, and wood, which he burns on the rice fields to give ash manure to the soil. But the produce must be strictly used for the supply of agricultural and domestic wants of the holder. And if timber, etc. is sold, the tenure is infringed, and government has the right to demand seigniorage on the book. In the Jamma tenure, as the bane is included in the Sanghi, it is virtually a part of the property. In the Sadhu tenure, there is no sanad, but the attached area of bane must be held and used subject to the same conditions. Under these circumstances, the bane cannot be regarded as actually the property of the tenure holder, nor, on the other hand, as land at the disposal of the government. It is rather land which is held as an appendage to a one or estate or to a Sadhu holding in a sort of trust or on condition for a certain use. In the note by Sri J.B. Lion on tenures in printed as appendix 4 in the Group Revenue Manual, there is nothing to indicate any difference from what is stated above in regard to the character of a bane holding. It would therefore appear that bane land held in association with a privileged one holding like Jamma and Umi land is in the possession and dominion of the holder, and that though they have no right to cut the timber and dispose it of for purposes other than for the service of the main holding, they can do so subject to payment of seigniorage, and that there is no absolute prohibition to their cutting the timber. In fact, the rule framed in regard to this matter, both under the Group Land and Revenue Regulation and the Forest Regulation, provide for the cutting of the timber by the holder on payment of seigniorage for the redemption of the timber, and they do not contemplate government permitting anyone other than the holder to cut or remove timber. Seigniorage itself represents not the full value of the timber, but a part of the value fixed from time to time, presumably with reference to the prevailing rates at the time of the promulgation of the rules. It is also significant to note that in the rules promulgated in 1953, provision is made for extraction and disposal of timber in government agency, and that the holder is entitled to 50% of net proceeds. The nature of the tenure and the above rules appear to indicate that holder has at least dominion over the timber, and whatever his accountability to government may be, any third party who interferes with the bane land is accountable to the holder. Therefore, the defendant's contention on this matter has been forced. As regards the rates, the learned judge has adopted the rates given in the plaint, since the rates fetched at the sales held by the Forest Department at Hunsur on 18/2/48 were higher than the rates mentioned in the plaint. The defendant has examined some witnesses to speak to the rates, but their evidence is of little value. PW2 Baswaya says that one Balaya has filed a suit against him claiming rupees 2 4 per cubic feet of one-day timber. He says Nandi was sold at ₹1 and rosewood at the rate of two and 4 annas per cubic foot. He has not maintained any accounts. DW3 Annaya, who is in the timber trade, speaks about timber sales. A statement of which is contained in a letter dated 23/6/49, addressed to him by the proprietors of Gauri Shankar Mills Hassan, to whom he says he has supplied timber. Neither his account books nor his customers' account books are produced. The rates in the letter can hardly be taken into consideration as evidence. DW4 Subramanian Sethi speaks to the rates as mentioned in Exhibit B4, which purports to be a statement of account sent by the defendant. It is dated 25/1/49. It no doubt mentions the rates at which different varieties of timber were sold. But this witness does not produce the accounts and rates mentioned in the statement of account contained in the letter can hardly be regarded as evidence. He has also produced Exhibit B8, a communication dated 28/2/48 from the Chief Forest Officer 2. Amongst the varieties of timber mentioned in it, the only relevant variety for which the rate is given is BT, and the rate is ₹2 and 3 annas, but the dimensions of the logs are not given. Apart from the evidentially value to be attached to a communication like this, it is difficult to take the rate into consideration in the absence of details regarding the dimensions of the logs for the trade would depend on them also. Thus, we are left with rates fetched in the Forest Departmental sale. There is no reason to dispute their correctness or authenticity. Lordship, this is mainly pertaining to the
This is a private dispute between two persons.
Lordship,
This is a private dispute between two persons.
2 persons.
Then the seigniorage was charged by the government.
Governments.
And the dispute was what is the value of the timber on which the seigniorage has to be paid.
Yes, the seigniorage is fixed by the government, and that amount is to be paid. And I think it's mainly because of the damage has been done by the British themselves by cutting forests, and even to this day we have the Tata coffee and all these. They're all in proper forest areas. And so thereafter, I think after the British settled, I think with just 30 years or so, when environmental laws started affecting the British. So that's how the burden was on the people.
But the issue in this, what do you want to rely on in this?
Yes, Lordships, my main thing is that I'm attacking the Chikera Koya's case, where the court has decided that the ownership of the Bane lands does not fall on the people.
That's not the issue. That's not an issue which has been decided in Rama Shetty's case.
No, that's not decided in that. But the fact is that the point that I'm trying to highlight is that the payment of seigniorage is not the cost of the wood. It is only a payment given to the government. It is the seigniorage, not the cost of the wood. And whatever is fixed, it was less than 50% at one time. Thereafter, it became 50%. So it is not the cost of the wood that one has to pay. So the liberty to cut the wood in their own lands. The Chikera case says that we have no right over the land. I think this was also not considered, this particular case was not looked into in the Chikera case.
But we, please proceed. Let's see.
Okay.
Please proceed. Let's see how you develop this argument.
Page 142, para 2. Another contention urged on behalf of the defendant is that if government collected seigniorage from him, it was reckoned on the value of the timber, and the rates adopted for that purpose should be accepted. This aspect of the matter has already been dealt with in another context, but it may be mentioned that the relevant rules, Rule 125 and 125A of the rules under the Group Land Revenue Regulation, published in the Group Land Revenue Manual, show that the seigniorage does not represent the market value or even the real value of the timber, but what would appear to be government share of the value of the timber. So this is what the government has been, they were just demanding their share of the timber.
Yes.
That could not be the criterion for deciding that the ownership of the land as such. Next matter. This is also not looked into in the G.K. Rapoya's case of 1963. I'm reading from page 140, the last paragraph of 146. The short point for consideration in this appeal is whether the finding of the learned district judge that the suit filed by the appellants in a civil court is not maintainable by virtue of section 145 of the Land and Revenue Regulation is correct. It is ideal for the appellants to contend that the suit is one for readjustment or reallotment of the maintenance provisions among the members of the Cook family and not for a partition of the properties. The parties are Coogis. They are governed by Mitakshara School of Hindu law as modified by the Cook customary law. The suit as brought now is clearly one for partition of the suit scheduled properties, which are admittedly joint family properties. It's not maintainable by virtue of section 145 of the Cook Land and Revenue Regulation. The contention of the appellant that the suit as brought by them is not a suit for partition as contended by the respondents, but is only a suit for readjustment of the maintenance division effected on 10/10/23 is an afterthought. We are unable to accept the contention of the learned counsel for the appellants that once the trial court allowed the amendment prayed for by the appellants and permitted them to delete the word partition in paragraph 7 of the plaint and to add the fresh allegation to the effect that the suit is only for increased maintenance. The suit cannot be considered to be one for fresh partition. There is no substance in the said contention. The allegations made by the appellants in the plaint make it abundantly clear that the suit is one for adjustment or reallotment of the properties allotted to the two branches under the deed dated 10/10/23. Even on the basis that the suit is one for readjustment of the properties, the suit is not maintainable. Section 145 of the Cook Land Revenue Regulation unmistakably ousts the jurisdiction of the civil court to entertain such suits. In para 160 of his book, A Manual of Cook Civil Law, Major General Rock Cole, Superintendent of Cook, dealing with the question whether a partition of the joint family properties amongst the members of the Cook family could be effected, as stated. Partition not allowed. It was not customary among Cooks to acquire or hold land, houses, etc. Since about 1805, however, some families quarreled and appealed to the former Rajas, who directed that they should, in accordance with the Hindu law, be allowed to divide. Subsequent to our assumption of the government of the country, several other families have similarly applied to the courts and obtained decrees for partition, while others have divided off amicably amongst themselves. In 1858, the Takas and headmen of the Cooks represented the loss and ruin occasioned to their ancient houses by this innovation and system of partition. And the Judicial Commissioner in additional Special AS number 117 of 1958-59 passed a decree declaring that division was contrary to the ancient custom of Cooks, and ever since division has been strictly interdicted. The learned counsel for the appellants is not able to point out to us any decision of any court which has taken a contrary view. Section 145 of the Cook's Land Revenue Regulation prohibits division of the joint family properties amongst the members of the Cook family, whether it be a partition or other allotment amongst the members of the family. According to this section, the suit for allotment of the joint family properties, even for the purposes of maintenance, is excluded from the jurisdiction of the civil court. Section 145 of the Land and Revenue Regulation, insofar as it relates for our purpose, is that 145 bar of suits in certain matters, except as otherwise provided by this regulation. No suit shall be brought in any civil court in respect of any of the following matters, namely. This is italic 15. Any claim for the partition of an estate or holding or any question as to the allotment of land when such estate, holding or land is one of which the land revenue has been wholly or partly assigned or released or which is held as joint family property by persons of the good grace or any claim for the distribution of land revenue on partition or any other question connected therewith, not being a question as to the partibility of or the title to the property of which partition is from. The above provision is quite clear. It is idle for the applicants to contend that in spite of such a clear provision, the jurisdiction of a civil court to deal with the allotment of the joint family property of the family is within the jurisdiction of a civil court. The learned district judge is therefore justified in holding that the suit filed by the applicants was not maintainable and dismissing the claim. Be the result, therefore, for the reasons stated about this appeal failed, same is dismissed. First. Provisions of the land revenue regulations continues as far as privileged lands are concerned. Privileged lands as shown in Rule 164 of the land revenue regulation. They'll have to go before a tahsildar or assistant commissioner for any kind of division of property within the family.
But if as a maintenance divisions.
Yes, maintenance divisions. Partition as such is not at all in practice in any family which is any good family.
Only as a maintenance division, one more division can be added. One more division or two more division can be added to the work, not the property going out of the work.
Going out of the
family.
Yes, out of the family.
Yeah.
Geologist, Department of Mining and Geology. Paragraph 51. This is the case where the owner is claiming a right over the mine.
Yeah.
The other material which prompted the High Court to reach the conclusion that the subsoil minerals best in the state is recitals of Pata, which is already noted by us earlier in para 12, which states that if minerals are found in the property covered by the Pata, and if the Patedar exploits those minerals, the Patedar is liable for a separate tax in addition to the tax shown in the Pata, and two certain standing orders of the collector of Malabar, which provided for collection of sewerage fee in the event of the mining operations being carried on. We are of the clear opinion that recitals in the Pata or the collector's standing orders that the exploitation of mineral wealth in the Pata land would attract additional tax, in our opinion, cannot in any way indicate the ownership of the state in the minerals. The power to tax is a necessary incident of sovereign authority, but not an incident of proprietary right, dominion. Proprietary right is a compendium of rights consisting of various constituent rights. If a person has only a share in the produce of some property, it can never be said that such property vests in such a person. In the instant case, the state asserted its rights to demand a share in the produce of the minerals worked. Though the expression employed is right, it is in fact the sovereign authority which is asserted. From the language of the PSO number 10, it is clear that such right to demand a share could be exercised only when the Patedar or somebody claiming through the Patedar extracts works the minerals. The authority of the state to collect money on the happening of an event. Such a demand is more in the nature of an excise duty or tax. The assertion of authority to collect a duty or tax is in the realm of sovereign authority, but not a proprietary right. On the basis of this point, the Chikera case was decided against the ownership of Banelands. 54, Mines and Minerals Act. Mines and Minerals Act is an enactment made by the Parliament to regulate the mining activities in this country. The said act does not in any way purport to declare the proprietary right of the state in the mineral wealth, nor does it contain any provision divesting any owner of a mine of his proprietary rights. On the other hand, various enactments made by Parliament, such as booking coal mines and coal-bearing areas, Acquisition and Development Act 1957, make express declarations under Section 4 and 7 respectively, providing for acquisition of the mines and rights in or over the land from which coal is obtainable. If the understanding of the state of Kerala that in view of the provisions of the Mines and Minerals Development Regulation Act 1997, the proprietary rights in mines stand transferred and vest in the state, it would be wholly an unnecessary exercise on the part of the Parliament to make laws such as the ones mentioned above, the nationalization of mines. Even with regard to the minerals which are greatly important and highly sensitive in the context of the national security and also the security of humanity like uranium, the Atomic Energy Act 62 only provides under Section 5 for prohibition or regulation of mining activity in such mineral. Under Section 10 of the Act, it is provided that the Government of India may provide for compulsory vesting in the central government of exclusive rights to work those minerals. The said Act does not in any way declare the proprietary right of the state. Similarly, the oil field regulation and development deals with oil fields containing crude oil, petroleum, etc., which are the most important minerals in the modern world. The Act does not anywhere declare the proprietary right of the state. For the above mentioned reasons, we are of the opinion that there is nothing in the law which declares that all mineral wealth, subsoil rights vest in the state. On the other hand, the ownership of subsoil mineral wealth should normally follow the ownership of the land, unless the owner of the land is deprived of the same by some valid process. In the instant appeals, no such deprivation is brought to our notice, and therefore we hold that the appellants are the proprietors of the minerals obtaining in their lands. We make it clear that we are not making any declaration regarding their liability to pay royalty to the state, as that issue stands referred to a larger bench. So far as the Chikera case is concerned, the court has heard and ruling that because mineral rights stands. And there are land, not all, in fact, almost all the lands do not have minerals as such, and nothing, nowhere, none of the banes are really exploited for. So, the conclusion of the court is erroneous. The next case is Para 6, Your Lordship's name. At the end of Para 6, if the word holds is intended to mean mere possession, regardless of the source of the right to hold such possession, there would be no need to use that word, as personal cultivation would necessarily imply possession. No question of personal cultivation would arise unless the person concerned happens to be in possession. So the word holds must have been deliberately used by the legislature to indicate holding in one's own right and not merely physical possession, irrespective of the question as to how that possession is obtained by the person concerned. If the intendment of the act is to confer the benefits thereof on any person who holds, which expression according to the learned counsel to the respondent should be interpreted as possessive. The land and personally cultivates it. The benefit should be available even to trespassers and persons holding unlawful possession of agricultural land. So this could never have been intended by the legislature, as the object was to help only persons holding a particular extent of land in their own right and cultivating it personally. To interpret the word owns as possessive without reference to the manner in which such possession was obtained would encourage unscrupulous and interested persons to take law into their own hands, the clutching and possession of agricultural lands belonging to others, just with a view to claim the benefits of the act and have their debts wiped out. Lordship, the next case. Your Lordship. Further question that arises is what is the meaning of the word? Argued that the expression whole should be understood in the context as whole. On the other hand, it was submitted that the expression whole is wide enough to include all types of holding property, whether by way of ownership or by way of possession. We are, however, not inclined to agree with this submission. In the context, we are of the view that the expression whole must be interpreted as equivalent to whole, as pointed out by the division bench in S. Lakshman Rao versus the Chinnapapa. It was held that the expression whole must have been deliberately used by the legislature to indicate holding in one's own right and not mere physical possession, irrespective of the question as to how that possession is deliberately. We observe that of the words whole is intended to mean mere possession, regardless of the source of the right to hold such possession. There would be no need to use that word as personal cultivation would necessarily imply possession. We agree with the observations and the observations in S. Lakshmana Rao versus Chinnapapa. Of course, the ownership may not be complete ownership, but there must be an element of ownership. For instance, person with a life estate or a vested remainder will also be held not have the complete ownership of the land in question. Next.
Yes.
Para 19. The next question is whether the custom of Udupi marriage would be a valid custom under law. In Edwards v. Jenkins, the characteristics of a valid custom are stated. They are that it must be of immemorial existence, must be reasonable, it must be certain, and it must be continuous. Every custom must have to be in existence preceding memory of man, and if the proof was carried back as far as living memory before, it should be presumed that the right claim had existed from time of living memory. This was reiterated in Muhammad Ibrahim versus Sheikh Ibrahim, in Ramalakshmi Amal versus Shivanta Perumal Tituravaya. It was held that it was the essence of special usages modifying the ordinary law, in that case of succession, that they should be ancient and invariable. It is further essential that they should be established to be so by clear and unambiguous evidence, and that it is only by reason, unambiguous evidence, and that it is only by means of such findings that the court can be assured of their existence, and that they possess the conditions of antiquity and continuity and certainty on which alone their legal title to recognition. Custom must be proved, and the burden of proof is on the person who asserts it. The Privy Council in Raja Rajendra Narayan versus Kumar Gangananda held that after the existence of a custom for some years has been proved by direct evidence, it can only, as a rule, be shown to be immemorial by hearsay evidence, and is for this reason such an evidence is allowed as an explanation to the general rule in DC Barabanki versus receiver of the estate of church. This being held that breach of a custom in a particular instance need not destroy it for all times. In Amisa versus Prabha. It was held that material custom must be proved in the first instance by calling witnesses acquainted with them until a particular custom has by frequent proof in the court become so notorious that the courts take judicial notice of it. A custom cannot be extended by logical process. In Saraswati versus Jagadamba, it has been held that oral evidence as to instances which can be proved by documentary evidence cannot be fairly relied upon to establish custom when no satisfactory explanation for withholding the best evidence is given. Custom cannot be extended by analogy and it cannot be established by a primary method. Udagar Singh versus laid down the ordinary rule is that a custom, general or otherwise, has to be proved under section 57 of the Evidence Act. However, nothing need to be proved of which the courts can take judicial notice. When a custom has been judicially recognized by the court, then it passes into the law of the land as proof of it becomes unnecessary. Under section 57(1) of the Evidence Act, in regard to marriage, says Shri Gurudas Banerjee, the ordinary Hindu law does not and cannot form the common rule for all sex alike. In this case, the customary law has been recognized by the courts. It used to be in both in the Madras High Court and also before the Mysore High Court. This
Yes.
all that this clause declares is that all existing laws, insofar as they are inconsistent with the provisions of Part 3, shall, to the extent of such inconsistency, be void. Every statute is prima facie prospective unless it is expressly or by necessary implication made to have retrospective operation. There is no reason why this rule of interpretation should not be applied for the purpose of interpreting our Constitution. We find nothing in the language of Article 31 which may be read as indicating an intention to give its retrospective operation. On the contrary, the language clearly points the other way. The provisions of Part 3 guarantee what are called fundamental rights. Indeed, the head of Part 3 is heading of Part 3 is fundamental rights. These rights are given for the first time by and under a constitution. Before the constitution came into force, there was no such thing as fundamental rights. What Article 13(1) provides is that all existing laws which clash with the exercise of the fundamental rights, which are for the first time created by the Constitution, shall to that extent be void. As the fundamental rights became operated only on and from the date of the Constitution, the question of inconsistency of the existing laws, which those rights must necessarily arise on and from the date those rights one can have no retrospective effect, but is wholly prospective in its operation. After this first point is noted, it should further be seen that Article 13(1) does not in terms to make the existing laws which are inconsistent with the fundamental rights void ab initio or for all purposes. On the contrary, it provides that all existing laws, insofar as they are inconsistent with the fundamental rights, shall be void to the extent of their inconsistency. They are not void for all purposes, but they are void only to the extent they come into conflict with the fundamental rights. In other words, on and after the commencement of the Constitution, no existing laws will be permitted to stand in the way of any of the fundamental rights. Therefore, the voidness of the existing law is limited to the future exercise of the fundamental rights. Article 13(1) cannot be read as obliterating the entire operation of the inconsistent laws or to wipe them out altogether from the statute book. Or to do so will be to give them retrospective effect, which we have said they do not possess. Such law exists for all past transactions and for enforcing all rights and liabilities that could before the date of the Constitution. Learned Counsel for the appellant has drawn our attention to Article 249, 250, 357, 358, and 369, where express provision has been made for saving things done under the law which expired. It will be noticed that each of those articles was concerned with expiry of temporary statutes. It is well known that on the expiry of a temporary statute, no further proceedings can be taken under it unless the statute itself saves pending proceedings. If therefore an offence had been committed under a temporary statute and the proceedings were initiated, but the offender had not been prosecuted and punished before the expiry of the statute, then in the absence of any saving clause, the pending prosecution could not be proceeded with after the expiry of the statute by efflux of time. It is on this principle that express provision was made in the several articles noted above for saving things done or omitted to be done under the expiring laws therein. As explained above, Article 13(1) is entirely prospective in its operation, and as it was not intended to have any retrospective, there was no necessity at all for inserting in that article any such saving clause. The effect of Article 13(1) is quite different from the effect of the expiry of a temporary statute or repeal of a statute by a subsequent statute. As already explained, Article 13(1) only has the effect of nullifying or rendering all inconsistent existing laws ineffectual or nugatory, and devoid of any legal force or binding effect only with respect to the exercise of fundamental rights on and after the date of the commencement of the Constitution. It has no retrospective effect, and if therefore an act was done before the commencement of the Constitution in contravention of the provisions of any law, which after the Constitution becomes void with respect to the exercise of any of the fundamental rights, the inconsistent law is not wiped out so far as the past act is concerned. For to say that it is will be to give the law retrospective effect. There is no fundamental right that a person shall not be prosecuted and punished for an offence committed before the Constitution came into form. So far as the past acts are concerned, the law exists, notwithstanding that it does not exist with respect to the future exercise of fundamental rights. We therefore agree to the conclusion arrived at by the report on the second question. On grounds. In view of that conclusion, we do not consider necessary to examine the reasons given for its conclusion. In our opinion, this appeal makes and is makes a dissenting vote.
Something is by Fazil Ali.
Okay.
Das J spoke for Tanya J, Patanjali, Mahajan, Chandrasekhar Iyer. Fazil Ali and Mukherjee are dissenting. Fazil Ali and Mukherjee are dissenting. If it's Fazil Ali, Mr. Mukherjee are dissenting. Separate judgment by.
Justice Fazil Ali who differed from the rest.
There seems to be a different judgment. That's what we are looking at. Das J is given one judgment. Fazil Ali, but it doesn't say on behalf of whom. Fazil Ali has separate judgment. Margin is a separate judgment.
Justice Mukherjee has agreed with Justice Fazil Ali. So this is
Mukherjee is in agreement with Justice Fazil Ali. Tanya, Fazil Ali, Patanjali, Shastri, and Merchant Martin. Purity judgment is by whom? Here it is. This is Kanya, Justice Patanjali Shastri, S.R. Das, Chandrasekhar Iyer, delivered by S.R. Das. Yes. Then Justice Fazil Ali and Justice Mukherjee was minority, dissenting. Yes.
We take care of Moya's case, they went by the opinion that is in between, more like a positive. Not take the.
We'll come to that one to take up that check.
Charan Singh Bandesh.
Yes.
Para 3.
But just one more. We'll just pass that one. Three. Middle over not put a correct 1, 2, 3 and cover.
Later on, they have given me the representation which they had given to the Joint Commissioner. That's the.
Our quote run you filing munche Pakistan. Shri Pawan Kumar has accepted notice for petition number 1, 2 and 4. Notice issue agala. Notice to
Third respondent is the private property, who has been, who has conducted construction.
notice to respond number 3 is deferred for now. Released on 17/8.
There is an order to have an inspection on
That is there.
9. Please.
That will continue. To get it done.
Obliged.
Notice to 1, 2, 4. Notice to respond number 3 is deferred for. Yes, ma'am.
Para 3.
Para 3.
Correct. Would the application to benefit be dismissed only because of enforcement of 1988 Act or the right of the applicant to get his application under the early act decided in accordance with law subsisted and survived under the new act as well? The answer shall depend on the construction of section 217, the repealing and saving provision in 1988 Act. There with section 6 of the General Clauses Act, subsection 1 of section 217 of 1988 Act, repeals 1939 Act. But subsection 2 saves certain notifications, rules, regulations, acts, etc. Clause B of subsection 2 reads as under. Notwithstanding the declared by subsection 1 of the repealed enactments, any certificate of fitness or registration or license or permit issued or granted under the repealed enactments shall continue to have effect after such commencement under the same conditions and for the same period as if this act had not been passed. On strength of this, it was urged on behalf of the respondents that the only saving was in respect of unexpired period of performance. However, what is relevant in subsection 4 of section 217 which provides as follows. Section 217(4). The mention of particular matter in this section shall not be held to prejudice or affect the general application of section 6 of General Clauses Act with regard to the effect of the deed. How such a provision should be construed was explained by this court in the Maharashtra Sugar Syndicate Limited versus Janardhan Ramchandra Kulkarni 1960. It is held that such a provision is not by way of abundant caution, and any proceedings pending under repealed act could be continued in view of Section 6 of General Clauses Act, Section 658 of Companies Act 1956, including its living property, which is considered by the court when is under. The mention of a particular matters in Section 645 to 657 or in any other provision of this act shall not prejudice the general application of Section 6 of the General Clauses Act of 1887 with respect to the effect of these. It should be noticed that acknowledging Section 58 of the Companies Act and Section 4 of Section 270 of the Motor Vehicles Act is identical. Therefore, the reasoning given in the decision squarely applies to construction of subsection 4 of Section 117. Consequently, it could not be successfully argued that subsection 2 of Section 117 is exhaustive and subsection 4 should be read by way of abundant caution and apply only to the field which is already covered by subsection 2. Section 6 of the General Clauses Act may now be extracted. Section 6, effect of repeal. Where this act, any central act or regulation made after the commencement of this act, if there is any enactment hitherto made or hereafter to be made, then unless the different intention appears, the repeal shall not. I will go directly to it will not affect any right, privilege, obligation, or liability acquired, accrued, or incurred under any enactment. The objectives of the provision is to ensure protection of any right or privilege acquired under the Repeal Act. The only exception to it is legislative intention to the contrary. That is, the Repealing Act may expressly provide or it may impliedly provide against continuance of such right, obligation, or liability. The controversy thus narrows down to if the renewal of a permit under 1939 Act was right. In other words, whether any right accrued to the applicant under the Repeal Act, which could be said to continue unaffected by the repeal of the Act, a permit could be renewed under Section 58(2) of the 1939 Act, which reads as under. Section 58(2), a permit may be renewed on an application made and disposed of as if it were an application for a permit, provided that the application for renewal of a permit shall be made in the case of a stage carriage permit or public carriage permit not less than 120 days before the date of its expiry, and in any other case not less than 50 days before the date of its expiry. Provided further that other conditions being equal, an application for renewal shall be given different or new applications for permit. Although the section uses the word may, but it provides very clearly, it creates a preference in favor of a permit holder to claim renewal if other conditions were equal. The holder of a permit thus stands on a better footing. The preference created by subsection 2, section 58 for consideration of the permit and its grant cannot be said to be a mere incoherent right or a right which does not exist in law. It may not be a vested right or a fundamental right, but it certainly is a civil right which could be enforced in a court of law, and any authority acting in contravention of it can be forced to act in accordance with it. For instance, if a regional transport authority under the old act renewal, even though the person applying for renewal was in all respects similar to other new applicants, then it could be corrected either by the tribunal or by way of the article. Therefore, it's a right which is enforceable in law. This right has been to applicant as we had already applied for renewal. The legal machinery was set in therefore had a right to get his application for renewal process and considered in accordance with 1939 Act. It will be too artificial to say that it was not a right or it had not accrued under 1939 Act. Therefore, in our opinion, by virtue of Section 60 of the General Clauses Act, the right to the applicant to get his application considered and decided in accordance with law was saved by subsection 4 of Section 217 of the Motor Vehicles Act. New religious and endowments and the person Lakshmi Kant. Regard precedence.
Yes.
Short service. Decision rendered by this court in Raghvendra Rao versus Deputy Commissioner does not appear to have been brought to the notice. We got the head notes, I think it suffice for investigate. The head note precedent.
Virtually it's saying per incurium, that's all.
Lordship?
Virtually saying is per incurium, because it is not brought to notice.
Yes. The next one is Municipal Corporation of Delhi versus Gurgaon Court.
Yes.
It is axiomatic that when a direction or order is made by consent of the parties, the court does not adjudicate upon the rights of the parties, nor does it lay down any principle. Portability as law applies to the principle of a case is ratio residence. The only thing in a judge's decision binding as an authority upon a subsequent judge is the principle upon which the case was decided. Statements which are not part of the ratio decision are distinguished as orbital dicta and not authoritative. The task of finding the principle is fraught with difficulty because without an investigation into the facts, as in the present case, it could not be assumed whether a similar direction must or ought to be made as a measure of social justice. That being so, the direction made by this court in Jagannath's case could not be treated to be a precedent. The High Court failed to realize that the direction in Jagannath's case was made not only to consent to the parties, but there was an interplay of various factors, and the court was moved by compassion to evolve a situation to mitigate hardship, which was acceptable by all the parties. The court, no doubt, made incidental observations into the directive principles of state policy enshrined in Article 38(2) of the Constitution. Instead, Article 38(2) of the Constitution mandates the state to strive to minimize, amongst others, the inequalities in facilities and opportunities amongst individuals. One who tries to survive by one's own labor has to be encouraged because for want of opportunity, destitution may disturb the conscience of the society. Here our persons carry on some paltry trade in an open space in scorching heat of Delhi, sun-free, freezing cold or torrential rain. They are being denied continuance in that place under the spacious plea that they constitute an obstruction to easy access to hospital. A little more space in the access to the hospital may be welcome, but not at the cost of someone being deprived of his livelihood, so as to swell the rank of the fast growing unemployed. As far as possible, this should be avoided, which we propose to do by this short order. This indeed was a very noble sentiment, but incapable of being implemented in a fast-growing city like the metropolitan city of Delhi, where public streets are overcrowded and the pavement squatters create hazard, vehicular traffic and cause obstruction to pedestrians on the pavement. Pronouncements of law, which are not part of the ratio decision, are classed as obiter dicta and are not authoritative. With all respect to the learned judge who passed the order in Jagannath's case, the learned judge will agree with him. We cannot conceive that this court is bound to follow it. It was delivered without argument, without reference to the relevant provisions of the Act, conferring express power on the municipal corporation to direct removal of encroachments from any public place like pavements or public streets and without any citation of authority. Accordingly, we do not propose to uphold the decision of the High Court because it seems to us that it is wrong in principle and cannot be justified by the terms of the relevant provision. Decision should be treated as given per incurring when it's given in ignorance of the terms of a statute or of a rule having the force of a statute. So far as the order shows, no argument is addressed to the court on the question whether or not any direction would properly be made compelling the municipal corporation to accept the stall at the pitching site of municipal corporation to construct the stall at the pitching site of a pavement squatter. Professor P.J. Fitzgerald, editor of the Summons on Jurisprudence, 12th edition, explains the concept of subsilent sure, page 153 first. The distinction past subsilent sure in the technical sense that has come to be attached to that phrase, when that the particular point of law involved in the decision is not perceived by the court or present to its mind. The court may consciously decide in favor of one part because of point A, which it considers it pronounces upon. It may be shown, however, that logically the court should not have decided in favor of the particular party unless it also decided point B in its favor. But point B was not argued or considered by the court. In such circumstances, although point B was logically involved in the facts and although the case had a specific outcome, the decision is not an authority on point B. Point B is said to pass subsilent sure. The notion of my case is that the Tikera case is cannot be relied upon because it is both against doctrine of state license, it is subsidized issue and it is passed in the ignorant issue. It's standard, I think.
It can't be all three. Subsilentio would enforce that judgment. Stare decisis or contrary to ratio decidendi.
Not referring to the previous judgment.
Per incurium, yes. But if you say subsilentio, that is deemed to have considered.
So that is not having been considered. The law as such.
If a judgment is being passed on particular point, which could not have been passed without holding another point in favor, then subsilentio it is held that that point has been decided in favor. Subsilentio may not help you. The subsilentio concept itself is completely different. Per incurium and subsilentio cannot go together.
It becomes per incurium because
Non-consideration. Non-consideration, yes, you'll have a point. But subsilentio, that's what we are wondering, why you are pressing in subsilentio to this matter.
I will permitted to examine that again.
Please examine.
Yes.
Subsilentio may not apply in your case.
In this case is Union of India versus Indian Railways. Para 5. Of the Union. Para 5.
Yes.
This decision of the tribunal is subject matter of various special leave petitions filed in this court. One of such petitions, SLP number 1349291, was the main petition in the present case. It has come up before a bench of 3 learned judges and was rejected summarily on 3991 without giving reasons. Thereafter, some other special leave petitions against the decision of different benches of the Central Administrative Tribunal on the same subject, including the said decision of the full bench, came up for this decision before a bench of 2 judges of this court. And the said bench, by its decision in Union of India versus Madras Civil Audit and Accounts Association, held that the posts were identified for the first time only with effect from 1/4/87. The revised pay scales could be paid to the holders of the said post only from that date and from no earlier date. In effect, therefore, this court by the said judgment did not approve of the said decision dated 2491 of the full bench of the tribunal, which had taken note that the revised pay scales should be fixed notionally from 1186 and consequently the difference between the pay scales from 1186 and 1487 should be paid to the employees. Consequent upon said decision of this court, it was pronounced on 4/2/92. A review petition was filed in the present proceeding on 21/2/92, which was heard by circulation and dismissed on 20/93. Obviously, without noticing the decision of the court pronounced on 4/2/92. For this reason, the present interlocutory application has been filed to resolve the anomaly between the two decisions of the court. After hearing the learned counsel, we are of the view that the full bench decision in the tribunal dated 26/1 requires rectification in the light of the decision of this court in Secretary Madras Civil Audit and Accounts Association's case, with which we are in complete agreement. Since the review petition was dismissed on 15/3/93 without noticing the said decision, it is needless to emphasize that the said dismissal does not come in our way for the view we are taking at present. Lordship, the state of Nuclear and other synthetic and chemicals limited and other. But the problem
Yes.
But the problem has arisen due to the conclusion in the case of synthetic chemical. The question was if the state legislature would levy revenue or excise duty on industrial alcohol. The bench answered the question in the negative, as industrial alcohol being unfit for human consumption. The state legislation was incompetent to levy any duty of excise either under entry 51 or entry 8 of this of the 7th schedule. While doing so, the bench recorded the conclusion extracted earlier. It was not preceded by any discussion. No reason or rationale could be found in the order. This gives rise to an important question. If the conclusion in case law declared under Article 141 of the Constitution, or it is peremptory and is liable to be ignored. Incuria literally means carelessness. In practice, peremptory appears to mean perentoria. English courts have developed this principle in relaxation of the rule of state license. The quotable in law is avoided and ignored if it is rendered in equalization of a statute or other binding authority. Young versus Historic Aeroplane Company Limited. Same has been accepted, approved, and adopted by this court while interpreting Article 141 of the Constitution, which embodies the doctrine of precedence as a matter of law. In Jayashree Sahu versus Raj Dev, this court, while pointing out the procedure to be followed when conflicting decisions are placed before a bench, extracted a passage from the Asbury's Law of England, incorporating one of the exceptions when the decision of an appellate court is not binding. Does this principle extend and apply to a conclusion of law, which was neither raised nor considered by any consideration? In other words, can such conclusions be considered as declaration of law? Here again, the English courts and jurists have carved out an exception to the rules of precedence. It has been explained as rule of sub silentio. A decision passes sub silentio in the technical sense that has come to be attached to that thing, when the particular point of law involved in the decision is not perceived by the court or presents to its mind. In Sermon on Jurisprudence, in Lancaster Motor Company London Limited versus Bremet Limited, the court did not feel bound by earlier decisions as it was rendered without any argument, without reference to the crucial words of the rule, and without any citation of the authority. It was approved by this court in Municipal Corporation of Delhi versus Gurgaon Court. The bench held that the present sub silentio and without arguments are of no moment. The courts thus have taken recourse to this principle for relieving from injustice perpetrated by unjust precedents. A decision which is not expressed and is not founded on reasons, nor it proceeds on consideration of issue cannot be deemed to be a law declared to have a binding effect as contemplated by Article 140. Uniformity and consistency are code of judicial discipline, but that which escapes in the judgment without any occasion is not issued as the We, Shamarao was the Union Territory of Pondicherry to observe, it is trying to say that the decision is binding not because of its conclusions, but in regard to its ratio and the principles laid down therein. Any declaration of conclusion and without application of mind or preceded without any reason cannot be deemed to be declaration of law or authority of a general nature binding as a precedent. Staying to dissenting or overruling is for sake of stability and uniformity, but rigidity beyond reasonable limits is inimical to the growth of law. Effort was made to support the conclusion indirectly by urging that the state, having raised some objections by way of legal petition, and the same having been rejected, it amounted impliedly as providing reasons for conclusion. Law declared is not that can be culled out, but that which is stated as law to be accepted and applied. A conclusion without reference to relevant provisions of law is weaker than even casual observation. In the order of Brother Thorman, the extracts from the judgment of the Constitutional Bench quoted in the extenso demonstrate that the question of validity of levy of sales and purchase tax was neither an issue, nor was it raised, nor is there any discussion in the judgment, except of course the straight argument advanced by the learned Attorney General to the following effect. But alcohol not fit for human consumption are not luxuries, and as such, the state legislatures, according to Attorney General, will have no power to levy tax on such alcohol. Sales tax or purchase tax under entry 54 is levied on sale or purchase of goods. It does not contemplate any distinction between luxury and necessity. Luxuries are separately taxable under entry 62, but that has nothing to do with entry 54. What prompted this submission is not clear. Neither there was any occasion, nor there is any constitutional inhibition or statutory restriction under the legislative entry, nor does the taxing statute make any distinction between luxuries and necessities for levying tax. In any case, the bench did not examine it, nor did it raise its conclusion on it. In absence of any discussion or any argument, the order was found on a mistake of fact. Therefore, it could not be held to be law declared. The bench further was not appraised of early constitutional bench decision in Next Chemicals versus State of Bihar and Ganga Sugar Mill versus State of Bihar, which specifically dealt with the legislative competence of levying tax, sales tax in respect of any industry which have been declared to be of public importance. Therefore, the conclusion of law by the Constitutional Bench that no sales or purchase tax could be levied on industrial alcohol with utmost respect fell in both the exceptions, namely silential and being inferior to the binding authority of the President. The next judgment is for our High Court Lordship, but I'm told that is being overruled by a division bench. That is well-written order.
Yes.
So I read it on.
This won't apply now.
No, sir.
This decision is not applicable. Section 115 as regards the MVCT. This may no longer be good law. Abdullah, you're waiting for something? Yes. The agenda. Next, what do you want us to take? What do you want us to take up after this? No, this book is over.
That book is over. I have some citations. One which I before, but it's not. I have not made a list. I'll make a list and I'll bring it.
When do we have?
The list of citations.
There was the 16th. When will you get, would you want to address your arguments on 10th? 10th, next Thursday?
Actually, it was posted for 7th of this month.
Monday.
Yes, month.
7th is Monday. You'll be ready with.
Surprising that it came up on what it said. We informing.
Okay. So when do you want this now?
Monday.
7th.
Yes, sir.
Third, further arguments of Mr. Vinimutana. For further arguments, released at 7. We'll again post it at 4. Let us see how it works.
ಇನ್ನೊಂದು ಕೇಸ್ ಇನ್ನೊಂದು ಕೋರ್ಟ್.
7th ರಿಲೈಸ್ ಆಯ್ತು. ಆಮೇಲೆ ಅವ್ರು ಕೇಳಿದ್ರು ಬೆಂಗಳೂರು ಮೇಲೆ ಕೇಳ್ತೀನಿ
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹಂಗಂತ ಇದೆ. ಹೇಳಿ ಸರ್.
ಯಾವ 2 ಮ್ಯಾಟ್ರ್ ಇತ್ತಲ್ಲ ಮೇಡಮ್ ಡಿಕ್ಟೇಟ್.
ಯಾವ್ದು ಸರ್? ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳ್ಬೇಕು.
ಅಲ್ಲಲ್ಲ 2ನೇ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಮೇಡಮ್.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ನೀವಿಲ್ವಲ್ಲ ಸರ್?
ನಾನಿದ್ದೀನಿ ಮೇಡಮ್ ಅದರಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್.
ಹೌದಾ? ಇಲ್ವಲ್ಲ ಸರ್? ಇಲ್ಲ. ಯಾವ ಕೋರ್ಟ್ಗೆ ಲಾಗಿನ್ ಆದ್ರಿ?
16ನೇ ಕೋರ್ಟಿಗೆ ಆದೆ.
ಸಾಹೇಬ್ರು ಯಾರು?
ಮುಗ್ದಮ್ ಸಾಹೇಬ್ರು ಮೇಡಮ್.
ರಾಂಗ್. ಅವ್ರಿಲ್ಲ.
ಹೌದು.
ಅವ್ರಿಲ್ಲ, ಧಾರವಾಡದಲ್ಲಿ ಇದ್ದಾರೆ ಸರ್.
ಮತ್ ನಮ್ಗೆ ಇವತ್ತು ಡಿಕ್ಟೇಷನ್ ಇತ್ತು ಆನ್ಲೈನ್ ಅಂತಂದ್ರು ಧಾರವಾಡ.
ಇಲ್ವಲ್ಲ ಸರ್? ಅವ್ರಿಲ್ವೇ ಇಲ್ವಲ್ಲ?
ಅದೇನೇನೆ
ಹಳೆ ಲಿಸ್ಟ್ ಸರ್ ಅದು.
ಅದ್ರ
ಅಂದ್ರೆ ನೀವು
ಅಲ್ಲ ಲಿಸ್ಟ್ 16ನೇ ಕೋರ್ಟ್ಗೆ ಕಳ್ಸಿದಾರ ಅದನ್ನ.
ಅಲ್ಲ ಲಿಂಕ್ ಹೆಂಗ್ ಬಂತು ಸರ್ ನಿಮ್ಗೆ? ಇದು ಏನಂತ ಬಂತು ಲಿಂಕ್?
ಲಿಂಕ್ ಏನು ಬಂದಿಲ್ಲ ಮೇಡಮ್. ವಿಡಿಯೋ ಬೈ ವರ್ಚುವಲ್ ಅಂತ ಇದೆ ಅಷ್ಟೇ.
ಏನೋ ಗೊತ್ತಿಲ್ಲ ಸರ್, ಅದು ಏನೋ ಮಿಸ್ಟೇಕ್ ಆಗಿರುತ್ತೆ. ಸಾಹೇಬ್ರು ಇಲ್ಲ ಆದ್ರೆ ಅವರು.
ಸರಿ ಮೇಡಮ್.
ಸುಮಾರು ಜನಕ್ಕೂ ಹಂಗೆ ಆಗಿದೆಯಂತೆ.
ಅದೇ ಎಲ್ಲಾರ್ದು ಹಾಗೆ ಆಗಿದೆ ಮೇಡಮ್.
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ನೋಡ್ಕೊಳ್ಳಿ, ಕೊಯ್ರಿ ಹಾಕ್ಬಿಟ್ಟು
ಸರಿ.
ಇನ್ನೊಂದ್ಸತಿ ಬಂದಾಗ ಸರಿಯಾಗಿರೋದು. ಅಕಸ್ಮಾತ್ ಬೆಳಗ್ಗೆ ನಿಮ್ಗೆ ಏನಾದ್ರು ಸೇಮ್ ಬಂತು ಅಂದ್ರೆ ಒಂದ್ಸತಿ ಟ್ರೈ ಮಾಡ್ಬಿಟ್ಟು ಹಿಂಗೆ ಕೇಳಿ. ಆಮೇಲೆ ಕಂಪ್ಯೂಟರ್ ಮೈನ್ ಸೆಂಟರ್ ಬೇರೆ ಲಿಂಕ್ ತಗೊಳ್ಳಿ.
ಸರಿ ಮೇಡಮ್.
ಮಾಡಿ.